Hello and welcome to your ultimate guide for the Illinois Real Estate Broker exam. My goal today is simple: give you everything you need to fully understand the key concepts, master them, and walk into your exam with total confidence. In this video we will cover questions from foreclosure rights, property conveyance, leasehold estates, fair housing, real estate finance. With over 100 plus success stories, we have proven our videos will help you pass your exam on the first attempt. And remember, our website offers free exam guides and practice questions to help you ace your exam. You'll find the link in the description below, so be sure to check it out and get the resources you need to study smarter, not harder. So let's get started.
Question 1. A buyer purchases a property at a Cook County Sheriff's sale following residential mortgage foreclosure. The buyer expects to receive the property after court confirmation of the sale. Which of the following best describes the borrower's rights during the redemption period? Your options are: A. Borrower must vacate immediately after sheriff's sale. B. Borrower has no remaining rights after sheriff's sale. C. Borrower may file new bankruptcy to delay confirmation. D. Borrower may redeem by paying full amount due to lender. Which one is it? Pause the video if you need more time. The correct answer is D. Borrower may redeem by paying full amount due to lender. D is correct because during the redemption period under the Illinois Mortgage Foreclosure Law, the borrower may pay the full amount due to redeem the property. For residential property, the redemption period is the later of 7 months from service of the complaint or 3 months from judgment. A is wrong because immediate vacating after the sheriff's sale would deprive the borrower of remaining redemption rights and possession. Illinois law gives the borrower the redemption period before confirmation, during which the borrower may retain possession and potentially redeem the property. B is wrong because the borrower retains redemption rights during the redemption period that runs through court confirmation. Treating the sheriff's sale as ending all rights would skip the redemption stage built into the Illinois foreclosure process, which protects borrowers up to the very end. C is wrong because filing new bankruptcy is a separate avenue with its own automatic stay implications. The redemption right under the Illinois Mortgage Foreclosure Law operates independently of bankruptcy, with the borrower able to redeem by paying rather than by filing for bankruptcy relief. After a foreclosure complaint is filed, Illinois law gives the borrower a final window to save their home by paying off the entire debt before the court confirms the sheriff's sale. This is the statutory right of redemption, and it operates on a precise legal clock. The redemption period ends on the later of 7 months from service of the complaint, or 3 months from judgment, and whichever arrives last. This dual measure protects borrowers whether the case moves quickly or drags on. During this entire time, the borrower typically stays in the home. On the broader timeline, reinstatement sits early, within 90 days of service, and only requires paying the arrears to cure the default. Redemption comes later and requires paying the full balance. Both rights protect the borrower, but at completely different stages of the same case. To redeem, the borrower must pay the entire amount due: principal, interest, attorney fees, and costs. Partial payments do not stop the foreclosure. Crucially, the lender cannot refuse a proper tender. This is a statutory right, not a negotiated one. The exam repeatedly tests redemption against reinstatement. When the facts show a borrower in the first 90 days paying arrears, that is reinstatement. When the borrower is paying the full balance before court confirmation, that is redemption. Hold those two apart, and the Illinois foreclosure timeline becomes clear. Question 2. A landowner records a deed conveying a parcel created in violation of the Illinois Plat Act, where the division required a plat but none was recorded. Which of the following best describes the criminal classification of recording the deed under the Plat Act? Your options are: A. Class C misdemeanor under the statute. B. Class X felony with mandatory prison. C. Civil infraction with a small fine. D. Administrative IDFPR sanction only. Take a second. Which answer would you pick? The correct answer is A. Class C misdemeanor under the statute. A is correct because recording a deed in violation of the Illinois Plat Act is a Class C misdemeanor under the statute. The deed itself is also voidable, and the county recorder may refuse to record without proper documentation of compliance or applicable exemption from the Plat Act. B is wrong because Class X felonies are reserved for the most serious offences such as armed robbery and aggravated criminal sexual assault. Recording an improperly platted deed is a regulatory violation that the legislature treats as a misdemeanor rather than a serious felony with mandatory prison time. C is wrong because a civil infraction with only a small fine would understate the legislature's choice to make Plat Act violations criminal. Classifying the act as a misdemeanor signals greater concern about land division records than a parking ticket would imply through purely civil enforcement. D is wrong because an administrative sanction from the Illinois Department of Financial and Professional Regulation would not reach a non-licensee landowner. The Plat Act enforcement is criminal and is also reinforced by the recorder's authority to refuse records, both of which fall outside the IDFPR's licensing structure. The Illinois Plat Act governs how raw land can be legally divided and documented. It exists because uncontrolled subdivision creates lasting problems, ambiguous boundaries, lost easements, and tangled chains of title that can persist for decades. Historically, developers sold lots to remote buyers with little formal record of where lot lines actually ran. The legislature responded by requiring that any meaningful land division be reflected in a formal plat showing dimensions, easements, dedications, and the relationship of new parcels to public roads. When a division requires a plat, the document must be prepared by a licensed surveyor, signed by the owner, approved by the local governing body, and recorded in the county where the land lies. Violating the Plat Act carries 3 layers of consequences. The deed becomes voidable, meaning the grantee can unwind the conveyance. The recorder may refuse to accept the deed entirely. And critically, recording a deed that violates the act is a Class C misdemeanor, punishable by up to 30 days in jail and a fine, even if all parties acted in good faith. The key exam signal is the combination of land division, no formal plat, and a deed recorded anyway. That scenario triggers the Plat Act, not the Real Estate License Act. Recording is never a rubber stamp. The act of filing a violating deed is itself a criminal offense on top of the civil problem. Question 3. A residential tenant transfers her entire remaining leasehold interest to another person for the balance of the lease term, with no portion of the term reserved to herself. Which of the following best identifies this transfer under standard landlord-tenant terminology? Your options are A. Sublease of less than the entire term. B. Novation releasing the tenant entirely. C. Assignment of the entire leasehold. D. Surrender by mutual lease termination. Before I reveal it, which one do you think is right? The correct answer is C. Assignment of the entire leasehold. C is correct because an assignment transfers the tenant's entire remaining interest in the leasehold to a new tenant. The assignee steps into the original tenant's shoes, though the original tenant typically retains liability unless released by the landlord through a separate agreement. Is wrong because a sublease transfers less than the entire term, with the original tenant retaining a reversionary interest. The transfer here covers the full remaining term with nothing reserved, which is the defining feature of an assignment rather than a sublease arrangement. B is wrong because novation substitutes a new party for the original tenant, and releases the original from liability, but this requires the landlord's consent. The assignment described here does not automatically release the original tenant, so calling it a novation overstates the legal effect. D is wrong because surrender ends the lease by mutual agreement of tenant and landlord. The transfer here moves the lease to a new tenant rather than ending it, which is a continuation under new occupancy rather than a termination of the leasehold itself entirely. When a tenant needs to transfer their lease to someone else, the law draws a sharp line between two very different arrangements. That line comes down to one question: how much of the remaining lease term is transferred? The leasehold transfer family has 4 members: assignment, sublease, novation, and surrender. Assignment hands off the entire remaining term. Sublease reserves some portion for the original tenant. Novation releases the original tenant entirely with landlord approval. Surrender ends the lease altogether. In an assignment, the assignee steps directly into the tenant's shoes, paying rent to the landlord and bound by all lease terms. In a sublease, the original tenant becomes the sub-landlord, and the subtenant has no direct relationship with the landlord at all. The cleanest rule in this area is the reservation test. If the original tenant transfers the entire remaining interest and holds nothing back, the result is an assignment. If even a single day is reserved at the end of the term, the transfer is a sublease, regardless of what the parties chose to call the document. When you see exam language like entire remaining interest, balance of the term, or nothing reserved, that is an assignment. The moment any time is held back, it becomes a sublease. Hold that line and these 4 terms stop blurring together. Question 4. A buyer signs a written buyer brokerage agreement with an Illinois firm at the first substantive meeting with the firm's licensee. Following the NAR Sitzer-Burnett settlement effective August 2024, which of the following best describes the post-settlement practice for buyer agreements? Your options are: A. Optional after first showing for realtor members. B. Prohibited under the NAR Code of Ethics. C. Required only for purchases over $1 million. D. Required before showing property by realtor members. What's your answer? Commit to one before I continue. The correct answer is D. Required before showing property by realtor members. D is correct because following the NAR Sitzer-Burnett settlement effective August 17th, 2020, realtor members must obtain a written buyer brokerage agreement before showing property to a buyer. The agreement must specify compensation which is no longer offered to buyer agents through the MLS. A is wrong because treating the agreement as optional after first showing would conflict with the settlement requirements that took effect for realtor members. The whole point of the settlement was to move buyer-broker compensation into transparent direct agreements before any showings occur. B is wrong because buyer brokerage agreements are not prohibited. They are required for realtor members. The settlement reformed how buyer-broker compensation is disclosed and negotiated, but it embraced the buyer agreement as the central instrument of the new compensation structure. C is wrong because there is no price threshold for the buyer agreement requirement. The settlement applies to residential transactions broadly, regardless of price, so $1 million threshold misstates the scope of the post-August 2024 buyer agreement rule under NAR practice. The Sitzer-Burnett settlement fundamentally changed how buyer agents are compensated in the United States. Starting August 17, 2024, 2 core rules now govern how realtor members handle buyer representation. Before the settlement, the seller funded both sides of every transaction through the MLS. The listing broker collected one commission and split it with the cooperating buyer's broker. The buyer had no direct role in compensating her own agent, and that arrangement was what the plaintiffs challenged as anti-competitive. The settlement restructured practice in 2 ways. First, offers of compensation to buyer brokers can no longer be advertised through the MLS. Second, Realtor members must obtain a written buyer brokerage agreement before showing any property. The written agreement must spell out the term, the geographic area, the agent's compensation rate, and the buyer's obligations, all agreed upon before the first showing. The MLS field that used to advertise cooperating compensation is gone entirely. The settlement didn't prohibit buyer agreements, it required them. Compensation can still flow from the seller if negotiated in the purchase contract, but the conversation about cost must happen up front, in writing, before any homes are shown. Question 5. The Illinois Human Rights Act protects against discrimination in housing based on certain classes that go beyond those covered by the Federal Fair Housing Act. Which of the following best identifies a class protected under Illinois law but not under the Federal Fair Housing Act? Your options are A. Source of income including Section 8 vouchers. B. Familial status protected for households with children. C. Race protected against intentional discrimination. D. Religion protected in all dwelling categories. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Source of income including Section 8 vouchers. A is correct because source of income, including Section 8 vouchers, is protected under Illinois law effective January 1st, 2023, but not under the Federal Fair Housing Act. Illinois' broader list also covers ancestry, age 40 plus, marital status, citizenship, military status, and order of protection status beyond federal protections. B is wrong because familial status is protected under both the Federal Fair Housing Act after the 1988 amendments and under Illinois law. The protection is not unique to Illinois and does not illustrate the broader scope of Illinois' anti-discrimination housing law beyond federal coverage. C is wrong because race is protected under both Illinois law and the Federal Fair Housing Act, along with the Civil Rights Act of 1866. It appears on essentially every anti-discrimination statute, so it cannot be the unique Illinois addition that distinguishes state law from federal law. D is wrong because the Federal Fair Housing Act already lists religion as a protected class, and Illinois mirrors that protection. Because the federal statute reaches religion directly, this class cannot serve as the unique Illinois addition the question is asking about here. The Illinois Human Rights Act extends housing discrimination protections well beyond what federal law requires. Understanding exactly where Illinois adds to the federal baseline is the core skill this topic tests. The Federal Fair Housing Act, amended in 1988, protects 7 classes: race, color, religion, national origin, sex, familial status, and disability. Illinois mirrors all 7 and then adds more. Illinois layers on additional protected classes the federal statute does not reach, including ancestry, age, marital status, military status, sexual orientation, gender identity, citizenship, pregnancy, and, most recently, source of income, effective January 1st, 2023. The Section 8 voucher program is the most tested source of income. The housing authority pays a portion of rent directly to the landlord, with the tenant covering the rest. Illinois law now makes categorical refusal of voucher holders a violation of state housing law. Federal law does not protect source of income. That protection is Illinois only. If an exam question lists source of income as a federal fair housing answer, it is wrong unless the question explicitly names Illinois law. When you see voucher, Section 8 or source of income, think Illinois Human Rights Act and January 1st, 2023. Question 6. Under the Federal Fair Housing Act as amended in 1988, certain classes are protected against housing discrimination by landlords: brokers, lenders, and other housing providers. Which of the following best identifies a class protected under the Federal Fair Housing Act? Your options are A. Marital status of the household members, B. Source of income including Section 8 vouchers, C. Familial status including children under 18, D. Age of the applicants of over 40 years. Which would you go with? Lock it in before the reveal. The correct answer is C. Familial status including children under 18. C is correct because familial status, added to the Federal Fair Housing Act by the 1988 amendments, protects households with children under 18, pregnant women, and persons securing legal custody. The federal classes are race, color, religion, national origin, sex, familial status, and disability. A is wrong because marital status is protected under the Illinois Human Rights Act, but not under the Federal Fair Housing Act. The federal list omits marital status from its protections, although ECOA does protect against marital status discrimination in credit decisions. B is wrong because source of income protection, including Section 8 vouchers, is an Illinois protection, effective January 1st, 2022. Not a Federal Fair Housing Act protection. The federal statute does not categorically protect voucher holders from refusal to rent decisions in residential housing. D is wrong because Illinois shields persons 40 and older against housing discrimination, but no parallel class appears on the federal list. Age discrimination shows up in the federal employment statute, the A, rather than in the federal housing scheme this question is asking about. The Fair Housing Act's protections didn't arrive all at once. The original 1968 statute left out two important groups, and Congress stepped in 20 years later to fix that. The 1988 amendments added exactly two new protected classes, familial status and disability. Before these additions, landlords could openly refuse families with children and face no federal consequences. Familial status is defined by household composition, not family structure. It covers any household with a child under 18, including pregnant women and anyone in the process of obtaining legal custody of a minor. Violations take two main forms: explicit refusal, where a landlord declines a family because of children, and discriminatory steering, where a licensee directs families towards specific units or away from certain areas. Remember that the Federal Fair Housing Act protects familial status but does not protect marital status or age. Marital status appears in Illinois law and the Equal Credit Opportunity Act, and age is addressed by employment law. Neither is a federal fair housing class. Question 7. A landlord and tenant in Aurora sign a written lease for an apartment with a fixed beginning date and ending date 1 year later, after which the lease automatically terminates without further action. Which of the following best identifies this leasehold estate? Your options are A. Tenancy at sufferance after holdover, B. Periodic tenancy month to month, C. Tenancy at will of either party, D. Estate for years with fixed term. Don't overthink it. Which one feels right? The correct answer is D. Estate for years with fixed term. D is correct because an estate for years is a leasehold with a fixed beginning and ending date, terminating automatically at the end of the stated term. The term may be any duration, including less than a year, despite the traditional name, as long as the start and end dates are fixed. A is wrong because a tenancy at sufferance arises when a tenant holds over after the lease ends. It describes the post-lease status of a holdover tenant, not the initial leasehold estate created by signing a fixed-term lease in the first place between the parties. B is wrong because a periodic tenancy renews automatically from period to period, such as month to month, until terminated by proper notice. The lease here ends automatically on a fixed date without periodic renewal, which is the defining feature distinguishing an estate for years from a periodic tenancy. C is wrong because a tenancy at will can be terminated at any time by either party. The lease here cannot be terminated early simply because either party chooses to end it. It runs for the fixed term and ends automatically when that term reaches its predetermined end date. Leasehold estates define how tenants hold possession of property, and the four basic types each operate by very different rules. Understanding which estate applies to a given situation controls everything from notice requirements to holdover rights. The estate for years has a fixed beginning date and a fixed ending date agreed upon at the outset. Because both endpoints are set in advance, the lease terminates automatically. No notice to vacate is required from either party. If the tenant holds over past the end date, she becomes a tenant at sufferance. Illinois recognizes four leasehold estates: the estate for years, the periodic tenancy, the tenancy at will, and the tenancy at sufferance. Each is created differently, continues differently, and ends differently, and the exam tests whether you can match a fact pattern to the correct estate. The estate for years is defined not by its length but by the certainty of its end date. A 1-week lease with fixed dates qualifies just as much as a 99-year ground lease. The periodic tenancy, by contrast, has no fixed end. It keeps renewing until one party gives the required notice. The signal words to look for are fixed beginning, fixed ending, automatically terminates, and no notice required. When both endpoints are specified at the outset, the answer is estate for years, regardless of what the legacy name implies about length. Question 8. A married couple takes title to their Oak Park residence as tenants by the entirety. A judgment creditor of the husband alone obtains a judgment and seeks to satisfy it through forced sale of the home. Which of the following best describes the creditor's position under Illinois law? Your options are: A. Creditor cannot reach the homestead. B. Creditor takes the wife's interest too. C. Creditor may force the sale immediately. D. Creditor takes half by partition action. Got a guess? Lock it in. The correct answer is A. Creditor cannot reach the homestead. A is correct because Illinois permits tenancy by the entirety only for the marital homestead. A creditor of one spouse alone generally cannot reach the entirety property to satisfy that spouse's debt, since neither spouse owns a divisible share that can be sold separately. B is wrong because a creditor of one spouse cannot acquire the other spouse's interest in entirety property to satisfy a debt the non-debtor spouse never incurred. The wife's separate interest is shielded along with the husband's because the estate is not severable by one alone. C is wrong because an immediate forced sale would treat the entirety interest as if it were a tenancy in common, but Illinois law specifically distinguishes the two. The protective feature of the entirety estate exists precisely to block individual creditors from reaching the homestead this way. D is wrong because partition is the equitable remedy that divides commonly held property or sells it when co-tenants cannot agree. It applies to tenancy in common and to severed joint tenancy, but the entirety estate is not divisible by either spouse alone. Tenancy by the entirety is a special form of co-ownership reserved exclusively for married couples. It treats the spouses not as two separate owners, but as a single legal unit, and that distinction has powerful consequences. The defining structural feature is the unity of person. Unlike joint tenancy, where each cotenant owns a separable share that creditors can reach, entirety property has no severable interest for a creditor to attach, because legally only one owner exists. Visualize the difference this way. In joint tenancy, a creditor can pierce one cotenant's share and force a partition sale. In tenancy by the entirety, the spouses merge into one owner and a creditor targeting only one spouse hits a wall. Illinois imposes specific limits. The estate applies only to the marital homestead, the couple's principal residence. Vacation homes and investment properties default to joint tenancy or tenancy in common. And if the couple divorces, the entirety ends and they become tenants in common. When an exam question describes a married couple's homestead and a creditor of one spouse trying to force a sale, entirety protection is the answer. Remember, one legal unit means no severable share, and no severable share means the creditor cannot reach the property. Question 9. Activities triggering Illinois real estate licensure under 225 ILCS 454(10) include negotiating, listing, and offering real estate for compensation. Which of the following best identifies an activity that triggers the licensure requirement? Your options are A. Selling personal property at a garage sale. B. Hiring a moving company for personal use. C. Negotiating a real estate lease for another for compensation. D. Receiving a gift of real estate from family. Which one is it? Pause the video if you need more time. The correct answer is C. Negotiating a real estate lease for another for compensation. C is correct because negotiating, listing, or offering real estate or business opportunities for sale, exchange, lease, or rental for another or for compensation triggers Illinois licensure requirements. Negotiating leases on behalf of others for compensation specifically falls within the activities the License Act regulates. A is wrong because selling personal property at a garage sale does not trigger real estate licensure. The License Act regulates real estate transactions, not personal property sales. So private sales of household goods are entirely outside the scope of the licensing requirement. B is wrong because hiring a moving company for personal use is not a real estate activity. The License Act regulates brokerage activities involving real estate transactions, not auxiliary services that consumers engage for their own moves or other personal logistical needs. D is wrong because receiving a gift of real estate from family is not a brokerage activity. The License Act regulates the activities of intermediaries facilitating real estate transactions, not the property transfers themselves between individual owners and recipients of gifts. The Illinois Real Estate License Act defines exactly which activities trigger the need for a license. Understanding the underlying logic, not just memorizing the list, is what lets you apply it quickly on the exam. The License Act rests on a two-pronged test. First, the activity must be performed for another person, not for yourself. Second, some form of compensation must change hands. Compensation doesn't have to be cash. A referral fee, a gift, or even a future commission all count. Think of it as two gates. The activity must pass through both to require a license. If someone is acting solely for themselves, like an owner selling their own home, the first gate stops it. If there's no compensation at all, the second gate stops it. Only activity that clears both gates falls under the Act. Several common scenarios fall outside the Act entirely. Selling or buying property for yourself, receiving real estate as a gift, managing your own rental properties, or helping a friend list their home with no compensation. None of these trigger the license requirement. When you see an exam scenario, run the two-prong check. Is the person performing a regulated activity for someone else? And are they being compensated in any form? If both answers are yes, the Illinois License Act applies. And acting without a license means unauthorized practice. Question 10. A seller in Lincoln Square plans to convey property to her adult son for no consideration as a gift. The transfer is exempt from Illinois transfer tax. Which of the following best describes what the parties must still do regarding the P-Tax 203 declaration? Your options are A. Skip the P-Tax 203 because the transfer is exempt. B. Wait until the next tax cycle to file. C. Pay the tax and seek a refund afterwards. D. File the P-Tax 203 with the exemption claimed. Take a second. Which answer would you pick? The correct answer is D. File the P-Tax 203 with the exemption claimed. D is correct because even exempt transfers require the PTX 203 transfer declaration to be filed with the deed, with the applicable exemption identified on the form. The recorder uses the declaration to verify that the exemption is properly claimed and that no tax is due on the transfer. A is wrong because skipping the PTX 203 would prevent the recorder from accepting the deed for recording. The form is part of the recording process whether or not tax is due, and exempt transfers must still document the basis for the exemption claimed by the parties on the declaration. B is wrong because waiting until the next tax cycle to file would delay recording the deed itself, leaving the buyer without recorded title. The PTX 203 is part of the recording packet at the time the deed is presented, not a periodic filing that can be delayed for any reason. C is wrong because paying the tax and seeking a refund would impose an unnecessary cash burden on a properly exempt transfer. The system provides for exemption to be claimed at the time of recording, not for the parties to first pay and then seek to recover the funds after closing. The Illinois Real Estate Transfer Declaration is a required document that travels with every recorded deed in the state. It sits at the intersection of recording law and transfer tax law, serving as both a tax instrument and a mandatory filing prerequisite. The Illinois transfer tax is structured in 3 layers: a state rate of 50 cents per $500, a county rate of 25 cents per $500, and an optional municipal rate on top. The transfer declaration collects the consideration amount, property identification, and party information used to calculate each layer. Illinois recognizes several common exemptions, including transfers for nominal consideration, gifts between spouses or to a child, transfers in lieu of foreclosure, court-ordered transfers, and transfers involving governmental units. Each exemption has a specific numbered identifier on the form that the parties must check. Whether tax is owed or the transfer is exempt, the recorder requires both the deed and the transfer declaration before accepting the recording. If tax is due, the recorder collects it. If the transfer is exempt, the recorder records the deed without collecting tax, but retains the declaration as documentation of why no tax was collected. The critical lesson is that exempt transfers still require the transfer declaration. The form is how the exemption is officially claimed and documented. Skipping the form means the deed cannot be recorded, regardless of whether any tax is actually owed. Question 11. Garn-St. Germain Depository Institutions Act of 1982 preempts state restrictions on enforcement of due-on-sale clauses for most residential mortgages, with certain exceptions. Which of the following best identifies a transfer that the Act protects from due-on-sale enforcement? Your options are A. Investor sale of property to a third-party buyer. B. Transfer to a spouse upon the borrower's death. C. Sale to a corporate entity for tax planning. D. Conveyance to a non-relative business partner. Before I reveal it, which one do you think is right? The correct answer is B. Transfer to a spouse upon the borrower's death. B is correct because Garn-St. Germain protects certain residential transfers from due-on-sale enforcement, including transfers to a spouse on the borrower's death, transfers to a living trust under which the borrower remains a beneficiary, and certain transfers incident to divorce. Ordinary arm's-length sales are not protected. A is wrong because an ordinary sale of property to a third-party buyer is exactly the kind of transfer the due-on-sale clause was written to capture. The lender may demand full payment in such a transfer, and Garn-St. Germain does not protect investor sales of mortgage property to outside buyers. C is wrong because a sale to a corporate entity for tax planning generally is not protected under Garn-St. Germain. Such a transfer changes the borrower's legal identity and looks like the kind of avoidance maneuver the due on sale clause aims to prevent under the statute's language. D is wrong because conveyance to a non-relative business partner does not fall within any Garn-St. Germain exception. The statute protects close family transfers and limited trust arrangements, leaving ordinary business transfers exposed to enforcement of the due on sale clause. The Garn-St. Germain Depository Institutions Act of 1982 is the federal statute that governs due on sale clauses in residential mortgages. It preempts state law and controls when a lender can demand full repayment after a property is transferred. A due on sale clause, also called an alienation clause, lets the lender call the entire loan balance due when the borrower transfers the property. Before Garn-St. Germain, some states blocked enforcement of these clauses. The Federal Act swept those restrictions away. The Act lists transfers the lender may not call due. These include transfers to a spouse or child upon the borrower's death, transfers to a surviving joint tenant, transfers incident to a divorce or property settlement, and transfers into a living trust where the borrower remains a beneficiary. By contrast, ordinary arm's-length sales to third-party buyers fall outside the protections entirely. Investor sales, sales to corporate entities, and conveyances to non-relative business partners are all transfers where the lender may enforce the clause and demand full payoff. The core principle to carry into the exam, Garn-St. Germain protects family and estate transfers from due on sale acceleration, but it does not shield ordinary market sales. When you see a family transfer in a question stem, the lender cannot accelerate. When you see a sale to a stranger, the clause applies. Question 12. A lender advertises a residential mortgage product by stating, only $20,000 down for your dream home. This statement is a trigger term under federal truth in lending advertising rules. Which of the following best identifies the additional disclosures the lender must provide? Your options are A. Down payment amount, repayment terms, and APR. B. Lender's branch addresses across the country. C. List of all available adjustable rate options. D. Federal funds rate at time of advertisement. What's your answer? Commit to one before I continue. The correct answer is A. Down payment amount, repayment terms, and APR. A is correct because when a truth in lending advertisement uses a trigger term, additional disclosures are required, including the down payment amount, terms of repayment, and the annual percentage rate. The rules ensure that consumers see the full picture rather than just the most attractive feature. B is wrong because branch addresses are not part of the trigger term disclosure framework. Federal advertising rules require specific financial information that allows consumers to compare loan offers, not corporate location data that has no bearing on the cost or terms of credit. C is wrong because surveying every adjustable rate option the lender carries would clutter the advertisement rather than satisfy a disclosure rule. Regulation Z requires specific items tied to the advertised product, leaving the lender's broader menu outside the scope of any required disclosure. D is wrong because the federal funds rate is set by the Federal Reserve and provides macroeconomic context but is not a required disclosure in residential mortgage advertising. Lenders disclose APR, repayment terms, and down payment when trigger terms are used, not benchmark monetary policy figures. The Truth in Lending Act, implemented through Regulation Z, governs how lenders must disclose credit terms in advertising. At its core is a concept called the Trigger Term Framework, one of the most tested topics in residential financing. A trigger term is a specific quantitative credit detail that, when used in an advertisement, obligates the lender to provide a fuller picture, The 4 trigger terms are the down payment amount or percentage, the number of payments or repayment period, the amount of any payment, and the amount of any finance charge. Once a trigger term appears, the lender must disclose 3 things: the down payment, the full repayment terms including any balloon payment, and the APR. The APR expresses the total cost of credit as a yearly rate, letting consumers compare loan offers on a standardized basis. Here is the key distinction. The exam tests a specific quantitative claim like only $20,000 down is a trigger term and requires full disclosure. A vague qualitative claim like low money down contains no specific number and does not trigger the rules. The policy behind this framework is straightforward. Lenders should not be able to advertise one attractive feature while hiding offsetting costs. Whenever a specific quantitative loan detail appears in an ad, the trigger term rules attach, and the down payment, repayment terms, and APR must follow. Question 13. An Illinois landowner whose property borders the Illinois River downstream of Peoria asks her broker about the rights that come with owning land adjacent to a flowing stream. Which of the following best identifies the body of rights that applies to her flowing water frontage? Your options are: A. Literal rights for tidal waters. B. Prior appropriation under federal law. C. Riparian rights for flowing waters. D. Mineral rights by rule of capture. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Riparian rights for flowing waters. C is correct because riparian rights apply to land bordering a flowing watercourse such as a river or stream. The riparian owner has reasonable use, access, and certain boundary rights, and the body of law is distinct from the rules governing land bordering standing water like a lake. A is wrong because literal rights attach to land bordering standing or tidal water such as lakes or oceans. The Illinois River is a flowing watercourse, so the applicable doctrine is riparian rather than literal, even though the two terms are often confused in casual usage. B is wrong because prior appropriation is a Western water rights system in which the first user to put water to beneficial use acquires superior rights. Illinois follows the Eastern riparian tradition tied to land ownership rather than appropriative use over time. D is wrong because the rule of capture historically applied to migratory minerals such as oil and gas, allowing the first to bring them to the surface to claim ownership. It does not govern surface water rights of landowners adjacent to a flowing river anywhere in Illinois. Riparian rights govern the water law for land that directly borders a flowing watercourse, a river or stream. Understanding riparian doctrine means knowing not just what it covers, but how it differs from the other water rights systems you'll encounter on the exam. A riparian owner holds 3 core entitlements: reasonable use of the water, access to it, and boundary rights tied to navigability. For non-navigable streams, the boundary runs to the centerline. For navigable streams, it stops at the ordinary high water mark. Exam writers test riparian against 3 confusable categories. Literal applies to standing or tidal water like lakes and oceans. Prior appropriation is the Western system based on first beneficial use, not land ownership. The rule of capture governs migratory minerals like oil and gas, not surface water, because the right is shared among all riparian owners along the watercourse. No single owner may dam the stream and consume all the water. The reasonable use standard balances the interests of upstream and downstream owners alike. The lasting signal is the motion of the water. A stem describing land touching a river or stream points to riparian doctrine and reasonable use. A stem describing a lake or ocean points to literal doctrine. Keep these 2 systems separate and you will not fall into the exam trap. Question 14. under the Mrs. Murphy exemption from the Federal Fair Housing Act. Owner-occupied housing of 4 or fewer units may be exempt from certain fair housing protections. Which of the following best describes a condition required for the exemption to apply? Your options are: A. Owner is over the age of 62 with reduced income. B. Owner provides written disclosure to all tenant applicants. C. Owner has at least 5 years of management experience. D. Owner does not use real estate brokerage services or discriminatory ads. Which would you go with? Lock it in before the reveal. The correct answer is D. Owner does not use real estate brokerage services or discriminatory ads. D is correct because the Mrs. Murphy exemption applies to owner-occupied housing of 4 or fewer units only when the owner does not use real estate brokerage services and does not publish discriminatory advertisements. The exemption never applies to race discrimination, which is barred without exception by the Civil Rights Act of 1866. A is wrong because the owner's age and income are not the levers of this carve-out. The federal rule turns on building size, owner occupancy, and the absence of brokerage and discriminatory ads, leaving the owner's personal demographics outside the analysis entirely. B is wrong because providing tenant applicants with written notices may be sound landlord practice, but the federal carve-out is not unlocked by paperwork. Building scale, owner occupancy, and channel choices trigger the exemption, not disclosures sent to prospective applicants. C is wrong because management experience plays no role in qualifying for Mrs. Murphy treatment. A first-time landlord with one rental can claim it on the same terms as a veteran landlord, since federal law looks at structure and conduct rather than seasoning. The Mrs. Murphy exemption is a Federal Fair Housing Act carve-out that gives small owner-occupied rental properties limited relief from anti-discrimination rules. It's narrow, technical, and a favorite exam topic precisely because it's easy to misstate. 4 conditions must all be present. The building can have no more than 4 units. The owner must personally occupy one of them. No broker or licensee can be involved in the rental, and no discriminatory ads can be published. The moment any one condition fails, the exemption disappears entirely. Picture a 3-unit Chicago building where the owner lives on the first floor and rents the 2 upper units. She posts a yard sign, uses no broker, and runs no ads. That setup is the textbook Mrs. Murphy example: small, owner-occupied, and entirely self-managed. Even a perfectly qualifying Mrs. Murphy landlord cannot discriminate based on race. The Civil Rights Act of 1866 bars race discrimination in property transactions with no owner-occupant exception. And a 5-unit building never qualifies no matter what. The size threshold is firm. The exam tests whether you know the real criteria: building size, owner occupancy, no broker, and no discriminatory advertising. Other factors like the owner's age or income are distractors. Keep those 4 elements in mind and you'll recognize the exemption and its limits every time. Question 15. A grandfather conveys his Evanston home to his daughter for the duration of her life, after which the property passes to his grandchildren. The daughter cannot sell more than what she holds, and the grandchildren take when she dies. Which interest does the daughter hold? Your options are: as a fee simple defeasible estate, B, a life estate measured by her life, C, a remainder interest in fee, D, a tenancy at will arrangement. Don't overthink it. Which one feels right? The correct answer is B, a life estate measured by her life. B is correct because a life estate gives the holder full enjoyment of the property for the duration of a measuring life. Here the daughters. She may sell, lease, or mortgage only her life estate and on her death the property passes automatically to the named remainder men. A is wrong because a fee simple defeasible is a full ownership interest that may be cut short by violation of a condition. The daughter does not hold any version of fee simple because her interest ends naturally on her death, not on the breach of any conditional limitation. C is wrong because the remainder is the interest held by the grandchildren, who take possession when the daughter's life estate ends. The daughter holds the present possessory estate, not the future interest waiting in the wings to take effect on her death. D is wrong because a tenancy at will is a leasehold estate that either party can terminate at any time. The daughter is not a tenant under a lease. She holds a present freehold estate created by conveyance with a duration set by her own lifetime. A life estate is a freehold ownership interest in real property that lasts only as long as a measuring life, not a fixed term, and not forever. It divides ownership between a present holder and a future taker. The life tenant holds full possessory rights. She may live in, lease, or mortgage the property. The measuring life sets the clock. When it ends, ownership passes automatically to the remainder man without probate or court action. Think of ownership as split across time. The life tenant owns the present use and the remainder man owns the future. The original conveyance itself triggers the transfer. No additional steps are needed when the measuring life ends. The life tenant has genuine ownership rights, but they are bounded. She cannot convey more than she holds, so any buyer or lender takes the same limited interest. She also owes a duty not to commit waste. She must not damage the property or deplete its value to the injury of the remainder man. A life estate is not a lease and not a fee simple. It is a present freehold limited by a measuring life, with a built-in future taker whose interest vests automatically the moment the measuring life ends. Question 16. A tenant with a documented mental health disability requests permission to keep an emotional support animal in a Chicago apartment that has a no pets policy. The landlord requires the animal to be removed. Which of the following best describes the landlord's obligation? Your options are: allow the animal as a reasonable accommodation. B. Require an additional pet deposit before approval. C. Limit the accommodation to certain species only. D. Approve the request only after vet inspection. Got a guess? Lock it in. The correct answer is A. Allow the animal as a reasonable accommodation. A is correct because emotional support animals are reasonable accommodations under the Fair Housing Act. The landlord must allow the animal despite the no pets policy, cannot charge pet fees or deposits, and may not impose species limitations beyond what is reasonable. Documentation supports the disability-related need. B is wrong because additional pet deposits are not permitted for assistance animals, including emotional support animals. The accommodation rules treat ETAs differently from pets, and charging deposits or fees would impose costs that the Fair Housing Act prohibits for animals serving a disability-related function. C is wrong because reasonable accommodation requires the landlord to permit the animal, and arbitrary species limitations may not be imposed. The Fair Housing Act does not categorically restrict species. Although highly unusual animals might raise reasonable concerns, the landlord could address through dialogue with the tenant. D is wrong because veterinary inspection is not part of the accommodation process. The landlord may request documentation from the tenant's healthcare provider supporting the disability-related need for the animal when the disability is not obvious. But veterinary inspection is not a permitted gating step. Under the Federal Fair Housing Act, emotional support animals are not pets. They are assistance animals that qualify as a reasonable accommodation for tenants with disabilities. Understanding this distinction is the core skill the exam tests. The Fair Housing Act places affirmative obligations on housing providers. When a tenant has a disability-related need for an emotional support animal, The provider must waive the no pets policy and cannot charge any pet-related fees. Species restrictions are only permitted in the narrow circumstance of a documented direct threat. There are two types of assistance animals: service animals, which are trained to perform specific tasks, and emotional support animals, which provide therapeutic benefit for mental health or emotional disabilities. Emotional support animals require no specialized training. The disability-related function is what triggers the accommodation requirement. When a tenant requests an emotional support animal, the provider may ask for reliable documentation from a treating healthcare professional if the disability is not obvious. The provider cannot demand veterinary records, breed certification, or proof of training. Online certificates from unknown sources carry less weight than documentation from the tenant's own treating professional. Remember, the moment an animal qualifies as an assistance animal under the Fair Housing Act, every standard pet rule falls away. No fees, no deposits, no breed bans, and no pets policies must yield. Question 17. Two business partners take title to a Rockford warehouse as joint tenants with right of survivorship. One partner dies still owning his interest. Which of the following best describes what happens to the deceased partner's interest in the property? Your options are: A. It escheats to the state of Illinois. B. It passes through the deceased's probate. C. It passes by survivorship to the co-owner. D. It passes to the deceased spouse first. Which one is it? Pause the video if you need more time. The correct answer is C. It passes by survivorship to the co-owner. C is correct because the defining feature of joint tenancy is the right of survivorship. On the death of one joint tenant, the deceased's interest does not pass through probate or by will. It goes directly to the surviving joint tenant by operation of law, free of the deceased's heirs. A is wrong because escheat applies only when a decedent leaves no will and no heirs at all. Even without joint tenancy, this property would pass to family members long before the state of Illinois could claim it through the doctrine of escheat to the sovereign. B is wrong because probate handles property the decedent owned individually or as a tenant in common, not joint tenancy interests. The survivorship feature deliberately routes the property around the probate court so the surviving co-owner takes immediately and without delay. D is wrong because a spouse may have certain marital rights, but those rights do not override the survivorship feature of a properly created joint tenancy. The surviving joint tenant takes the interest first. The deceased spouse cannot leapfrog over the surviving co-owner. Joint tenancy is a form of co-ownership where two or more people hold equal shares in real property with a right of survivorship. The defining feature is that when one joint tenant dies, their interest passes instantly to the survivor by operation of law, bypassing probate entirely. Creating a valid joint tenancy requires 4 unities: time, title, interest, and possession. If any unity is missing at creation, or destroyed afterward, the joint tenancy fails or converts into a tenancy in common. When one joint tenant dies still holding their interest, that share extinguishes and the survivor's share automatically enlarges to cover the whole property. No deed, no court order, and no probate proceeding is required. The transition is instant and automatic. Exam questions test joint tenancy against 3 confusable forms: tenancy in common as Illinois' default and lacks survivorship. Tenancy by the entirety is limited to married couples and the marital homestead. Probate handles individually owned property but cannot reach a joint tenancy interest because survivorship operates before probate begins. The classic exam trap involves heirs or a spouse claiming the deceased joint tenant's share. Remember, the surviving joint tenant takes immediately by operation of law, and the deceased will. Heirs and interstate successors cannot reach that interest. Survivorship always wins. Question 18. A buyer pays 2 discount points on a $400,000 mortgage to reduce the interest rate. Which of the following best describes the dollar amount the 2 discount points represent under standard real estate finance terminology? Your options are A. 2% of the purchase price, B. 2% of the appraised value, C. A flat fee of $2,000, D. 2% of the loan amount. Take a second. Which answer would you pick? The correct answer is D. 2% of the loan amount. D is correct because 1 discount point equals 1% of the loan amount. So 2 points on a $400,000 loan total $8,000. Points always reference the loan amount, never the purchase price, appraised value, or a fixed dollar figure in standard mortgage terminology. A is wrong because tying points to the purchase price would give different results when the buyer makes a large down payment and borrows less. The convention deliberately ties points to the loan amount, so the calculation reflects the size of the borrowing rather than the size of the underlying purchase price. B is wrong because appraised value plays a role in determining LTV, but not in computing points. Points are measured against the loan amount only, so a different appraised value does not change the calculation when the loan amount itself remains the same in the closing documents. C is wrong because a flat fee figure ignores the size of the loan and would shortchange lenders on larger loans or overcharge borrowers on smaller ones. Points are always a percentage of the loan amount, which scales them appropriately to the size of the financing being arranged at closing. Discount points are an upfront fee paid at closing in exchange for a lower interest rate on your mortgage. Understanding exactly how they're calculated is the core skill being tested here. 1 discount point equals 1% of the loan amount, not the purchase price, not the appraised value, nothing else. Each point typically reduces the interest rate by about 1/4 of a percentage point, and the lender ties this trade-off to the loan amount because that is what the interest rate actually applies to. Picture a borrower taking out a $400,000 mortgage and paying 2 discount points. 2% of $400,000 is $8,000 paid at closing. In return, the lender provides a reduced interest rate for the entire life of the loan. It's important not to confuse discount points with origination points. Discount points are optional and purchased specifically for a rate reduction. Origination points compensate the lender for processing the loan and do not lower your interest rate. Both are expressed as a percentage of the loan amount. When an exam question gives you both a purchase price and a loan amount, always compute points against the loan amount. The purchase price is a distractor. The correct denominator is always the loan amount, no exceptions in standard mortgage finance. Question 19. A licensee represented a buyer 6 months ago in purchasing a Naperville residence. The representation has ended. A third party now asks the former licensee what price the buyer's prior purchase actually closed at, off the public record. Which of the following best describes the licensee's duty? Your options are A. Confidentiality automatically ends upon closing. B. Confidentiality survives termination of the agency. C. Confidentiality applies only to current clients. D. Confidentiality is waived by passage of time. Before I reveal it, which one do you think is right? The correct answer is B. Confidentiality survives termination of the agency. B is correct because the duty of confidentiality survives the termination of the agency relationship. Information protected during the representation remains confidential after the agency ends, restricting the former licensee from disclosing non-public details obtained while representing the now former client. A is wrong because treating confidentiality as ending at closing would leave the client exposed precisely when they no longer have an ongoing relationship to protect them. The duty extends past closing because the harm from disclosure would persist long after the formal representation has concluded. C is wrong because limiting confidentiality to current clients would defeat the duty's protective purpose. The doctrine deliberately covers former clients to ensure the agent's loyalty is not just a passing convenience but a lasting commitment that the client can rely on after the agency ends. D is wrong because passage of time alone does not waive confidentiality. The information remains protected indefinitely, and only specific events such as the client's express waiver or legal compulsion would allow disclosure after the representation has ended. One of the most tested nuances in Illinois agency law is that the duty of confidentiality does not end when the representation ends. Unlike most obligations that expire at closing, confidentiality follows the former licensee indefinitely. Illinois agency law recognizes 6 fiduciary duties. 5 of them are bounded by the act of representation, but confidentiality is different. Its protection of non-public client information persists after the agency ends. The shield of confidentiality covers non-public details the client shared during representation. Bottom line price, financial weaknesses, motivations, negotiating strategy, and that shield does not lower when the transaction closes. The duty yields in only 4 defined situations. The client expressly waives it, a court orders disclosure, law compels it, or the licensee must reveal information to defend herself against a claim. Passage of time, closing, and moving to new clients are not exceptions. When an exam stem places a former licensee months or years after closing and asks whether she may share what she learned, the answer is no. The duty lasts until the client waives it or law compels disclosure, neither of which arises in the ordinary course. Question 20. 2 parties in a Lakeview transaction sign a written contract for the sale of residential real estate. The seller is an adult of sound mind. The buyer is a competent adult, and they exchange promises supported by valuable consideration. Which of the following best identifies a fundamental element of contract formation present here? Your options are A. Offer, acceptance, and bargained for consideration. B. Tender of immediate possession at signing. C. Recording of the deed with the county recorder. D. Independent appraisal supporting the price. What's your answer? Commit to one before I continue. The correct answer is A. Offer, acceptance, and bargained for consideration. A is correct because contract formation requires offer, acceptance, consideration, capacity, mutual assent, and legality. The parties here have each made promises supported by consideration, demonstrating the basic elements of a valid bargain that the law will recognize and enforce. B is wrong because tender of immediate possession is not a fundamental element of contract formation. Possession typically follows closing, not contract signing, and many valid contracts contemplate delayed possession or rent-back arrangements between buyer and seller without affecting validity. C is wrong because recording the deed transfers public notice of ownership, but is a step that follows closing, not an element of forming the underlying contract. The contract is valid between the parties at signing, even before any recording occurs at the county recorder's office. D is wrong because an independent appraisal supports lender underwriting but is not an element of contract formation. Parties may form a binding sale contract without any appraisal, with the appraisal entering the picture later through a financing contingency or lender review. Contract formation is the legal moment when a binding agreement comes into existence. Before that moment, there is only negotiation, no enforceable obligation. Understanding what creates a contract is essential for real estate practice and exam success. Every contract requires 6 elements: offer, acceptance, consideration, capacity, mutual assent, and legality. In Illinois real estate, a seventh requirement applies. Writing. Because the statute of frauds governs most real estate contracts. If any single element is missing, no enforceable contract exists. The offer must be definite and show intent to be bound. Acceptance must mirror those terms. A counter-offer rejects the original offer and creates a new one. Consideration is the bargain for exchange. Past consideration does not qualify. Capacity means both parties must have the legal ability to contract. When the seller makes a definite offer and the buyer accepts on those exact terms, and each party gives and receives consideration. Here, a promise to convey property for a promise to pay. The meeting of the minds is complete. The signed written contract captures that moment. Formation happens the instant all 6 elements come together, typically at signing. Closing, recording, and appraisal come later and belong to performance or risk management, not formation. The deeds recording transfers public notice of ownership. It does not create the contract between buyer and seller. Question 21. 2 real estate firms in Aurora agree that they will not cooperate with a particular discount broker in their market and will refuse to cooperate on transactions involving that broker. Which of the following best identifies this practice under antitrust law? Your options are A. Permitted competitive response to competition. B. Price fixing as horizontal restraint. C. Group boycott as per se Germain Act violation. D. Tying arrangement requiring rule of reason. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Group boycott as per se Germain Act violation. C is correct because a group boycott among competitors agreeing not to deal with a particular competitor is a per se violation of the German Antitrust Act. Like price fixing, group boycotts are categorically illegal without requiring proof of actual harm, given their tendency to suppress competition. A is wrong because permitted competitive response does not include collective refusals to deal with the competitor. Independent decisions by individual firms are permitted, but coordinated boycotts cross the line into illegal restraint of trade and trigger the harshest antitrust treatment. B is wrong because price fixing involves agreements to set prices among competitors. The agreement described is about refusing to deal with a competitor rather than setting prices, so the conduct is a group boycott rather than price fixing under the antitrust framework, though both are per se illegal. D is wrong because tying arrangements condition the sale of one product on another. The conduct here is a coordinated refusal to deal with a particular competitor, not a tying arrangement. So the rule of reason analysis applicable to tying does not apply to the per se illegal boycott. A group boycott happens when competing brokers coordinate to refuse dealing with a particular rival. This kind of conduct falls under the German Antitrust Act, and understanding why it's treated so seriously requires looking at how antitrust law categorizes harmful agreements. The Germain Act gives courts 2 analytical tools. Rule of reason analysis weighs benefits against harms, but per se analysis skips that balancing entirely. Certain agreements are automatically illegal because their damage to competition is so obvious and predictable that no justification could save them. Group boycotts sit in the same category as price fixing, market allocation, and bid rigging. All 4 are per se violations. What they share is a coordinated agreement among horizontal competitors that predictably harms competition with no plausible pro-competitive justification. When 2 or more brokers at the same competitive level privately agree to freeze out a discount rival, refusing to show its listings or bring offers on its properties, that coordinated refusal is a horizontal group boycott. The agreement itself is the violation. Proof of harm to specific transactions is not required. The critical line is coordination. An individual broker may independently choose not to work with a particular firm. But the moment competing brokers agree together to exclude a rival, they've crossed into per se illegal territory, exposing themselves to criminal penalties, prison, and civil treble damages. Question 20 out. A seller in Oak Park engages multiple brokers under separate non-exclusive arrangements, where each broker may attempt to sell the property and only the broker actually procuring the buyer earns commission. Which of the following best identifies this type of listing? Your options are A. Net listing disfavored in Illinois. B. Exclusive right to sell listing. C. Exclusive agency listing. D. Open listing with multiple brokers. Which would you go with? Lock it in before the reveal. The correct answer is D. Open listing with multiple brokers. D is correct because an open listing is a non-exclusive arrangement where multiple brokers may attempt to sell, with commission earned only by the broker procuring the buyer. The seller may also sell directly without commission, and brokers have less incentive to market because of the competition. A is wrong because a net listing pays the broker the excess over a stated net amount. The arrangement here uses standard procurement-based commission with multiple brokers, not a net above structure with a single broker, and net listings are heavily disfavored in Illinois practice. B is wrong because an exclusive right to sell engages a single broker with rights to commission on any sale during the term. The arrangement here is open to multiple brokers, which is the opposite of exclusivity and undermines the protection that the right to sell structure provides. C is wrong because an exclusive agency limits commission rights to one engaged broker if that broker procures the buyer, while the seller can still sell directly without commission. The non-exclusive multi-broker setup the question describes is a fundamentally different structure. When a seller lists a property, the type of listing agreement determines who earns a commission and under what conditions. Understanding the four major listing types in Illinois practice is essential for both brokers and sellers. Illinois recognizes four listing structures: the open listing, the exclusive agency listing, the exclusive right to sell, and the net listing. Each allocates commission rights differently, creating distinct incentives for brokers and distinct levels of protection for sellers. In an open listing, multiple brokers compete to procure a buyer, but only the broker who actually delivers a ready, willing, and able buyer earns the commission. If the seller finds a buyer directly, no listing side commission is owed at all, because any competing broker or even the seller can undercut their efforts. Brokers have little incentive to invest heavily in marketing an open listing. Exclusive arrangements protect the broker's marketing investment, which is why exclusive right to sell listings tend to attract the most dedicated broker effort. The net listing is the outlier. The broker keeps whatever the sale price exceeds the seller's target net amount. This creates a built-in conflict of interest because the broker benefits from a higher price gap. Illinois strongly discourages net listings, and licensees should treat them with extreme caution. Question 23. A senior housing community in suburban Chicago restricts occupancy to persons 62 and older. The Federal Housing for Older Persons Act provides an exemption from certain fair housing protections for qualifying senior housing. Which of the following best describes the exemption HOPA provides? Your options are A. Exempt from all fair housing requirements entirely. B. Exempt from familial status protection only. C. Exempt from race discrimination prohibition. D. Exempt only with state regulator approval. Don't overthink it. Which one feels right? The correct answer is B. Exempt from familial status protection only. B is correct because the Housing for Older Persons Act exempts qualifying senior housing from the familial status protection of the Fair Housing Act. Qualifying housing must meet specific requirements such as restricting occupancy to persons 62 and older, or having 80% of units with at least one occupant 55 or older with HOPA compliant policies. A is wrong because HOPA does not exempt senior housing from all fair housing requirements. Race, religion, national origin, and other protections continue to apply, with only the familial status protection being relaxed for qualifying senior housing under the limited carve-out. C is wrong because race discrimination remains prohibited even in qualifying senior housing under HOPA. The exemption is narrow, addressing only the conflict between senior housing operations and the familial status protection, not exempting race or other categories from anti-discrimination law. D is wrong because HOPA does not require state regulator approval before the exemption applies. The exemption operates based on the housing's compliance with HOPA's structural requirements, with self-certification rather than agency approval as the standard mechanism for claiming the exemption. The Housing for Older Persons Act, or HOPA, creates a narrow federal exemption from the Fair Housing Act. It allows qualifying senior housing communities to legally exclude families with children, something that would otherwise violate the familial status protection added to the Fair Housing Act in 1988. HOPA recognizes two qualifying categories. The first requires every occupant to be 62 or older, no exceptions. The second requires that 80% of occupied units have at least one resident who is 55 or older, allowing more flexibility for the remaining 20%. The 55 and older category carries 3 additional requirements. The community must publish and follow policies demonstrating its senior housing intent, comply with HUD verification procedures, and conduct periodic surveys. Failing any of these conditions can cost a community its HOPA qualifying status. The exemption is deliberately narrow. HOPA removes only the familial status protection for qualifying communities. Race, color, religion, national origin, sex, and disability remain fully protected under federal law. A senior community cannot turn away applicants based on race or any other non-exempted class. The exam tests whether students confuse HOPA's limited carve-out with a broad fair housing exemption. It is not. HOPA permits qualifying senior communities to exclude families with children, and nothing more. Every other Fair Housing Act protection remains fully in force. Question 24. A real estate licensee shows minority buyers properties only in minority-majority neighborhoods and steers white buyers away from those same areas. Which of the following best identifies this prohibited practice under federal fair housing law? Your options are A. Steering based on protected characteristics. B. Blockbusting by inducing panic sales. C. Redlining of geographic areas by lenders. D. Disparate impact through neutral policies. Got a guess? Lock it in. The correct answer is A. Steering based on protected characteristics. A is correct because steering directs prospective buyers toward or away from neighborhoods based on protected characteristics, such as race. The practice is prohibited even when the licensee believes she is being helpful by matching buyers with neighborhoods where they might feel more comfortable based on demographics. B is wrong because blockbusting induces sales by representing that minority groups are moving into the neighborhood. The conduct described is steering buyers to particular areas, not inducing existing residents to sell. So the blockbusting category does not match the licensee's described conduct. C is wrong because redlining is denying or discouraging mortgage lending, insurance, or services in specific geographic areas based on demographics. The conduct described is by a real estate licensee steering buyers, not by a lender or insurer denying services in geographic areas. D is wrong because disparate impact involves facially neutral policies that have disproportionate negative effects on protected classes. The conduct described is intentional differential treatment based on race, which is direct disparate treatment rather than the neutral policy disparate impact framework. Steering is a prohibited practice under the Federal Fair Housing Act in which a licensee directs buyers or renters toward or away from neighborhoods based on a protected characteristic. It is treated as a per se violation, meaning intent doesn't matter. The Fair Housing Act covers 7 protected classes: race, color, religion, national origin, sex, familial status, and disability. Steering violates the Act whenever a licensee filters housing choices through any one of these characteristics. In practice, steering looks like this. The same licensee shows different neighborhoods to different buyers based on perceived race or family composition, rather than the buyer's stated preferences. The buyer never sees the full range of available options. Students often confuse steering with 3 related concepts. Blockbusting induces owners to sell by claiming minority groups are moving in. Redlining is when lenders or insurers deny services based on neighborhood demographics. Disparate impact involves facially neutral policies with disproportionate effects. Steering is specifically about the licensee directing buyers. The core principle is simple. A licensee's job is to present every available option that meets the buyer's stated criteria and leave the choice entirely to the buyer. Filtering neighborhoods through demographic assumptions, however well-intentioned, is steering and violates federal law. Question 25. A tenant with a mobility disability requests permission to install grab bars in the bathroom of a Schaumburg rental apartment. The landlord refuses. Which of the following best describes the landlord's obligation under federal disability law? Your options are: A. Deny the request because modifications damage property. B. Install grab bars at landlord's expense as accommodation. C. Permit modification at tenant's expense with restoration possible. D. Require professional contractor only at premium cost. Which one is it? Pause the video if you need more time. The correct answer is C. Permit modification at tenant's expense with restoration possible. C is correct because A. Reasonable modification is a physical alteration of the dwelling that the tenant typically pays for. The landlord must permit the modification when needed for full use of the unit by a disabled tenant, and may require restoration to original condition at the end of the tenancy for certain modifications. A is wrong because denying the request because of property modification concerns conflicts with the disability law. Tenants have the right to modify their unit at their own expense when needed for full use, and the landlord can require restoration but cannot block reasonable modifications entirely. B is wrong because reasonable accommodations are policy changes the landlord pays for, while reasonable modifications are physical changes the tenant pays for. Grab bars are physical modifications, and the cost responsibility typically falls on the tenant who needs the change to use the unit fully. D is wrong because requiring a premium cost professional contractor would impose costs beyond what the law contemplates. The tenant may use a competent contractor, and the landlord cannot dictate cost levels that effectively block the modification through prohibitive contractor requirements. Under the Fair Housing Act's 988 Disability Amendments, disabled tenants have 2 distinct tools to secure equal housing access: reasonable modifications and reasonable accommodations. Understanding the difference, especially who pays, is essential. A reasonable modification is a physical alteration to the dwelling, like grab bars or a ramp. A reasonable accommodation is a policy adjustment, like waiving a no pets rule for an assistance animal. The tenant funds physical modifications, the landlord absorbs the cost of policy accommodations. Common modifications include grab bars, widened doorways, entrance ramps, and lowered counters. The landlord must permit these changes even though the tenant pays for them, provided the work is done properly with required permits. While the landlord cannot block a modification, they may require that work be done in a workmanlike manner with proper permits. They can also require restoration of the unit at lease end, though widely useful changes like grab bars often don't require it, but cannot impose unreasonable conditions to obstruct the tenant. The lasting divide is simple. Physical modifications are funded by the tenant. Policy accommodations are funded by the landlord. Both are protected rights under federal disability law, and the landlord cannot refuse either one. Question 26. A senior homeowner in Cook County who meets the program's income limit applies for the Senior Citizens Assessment Freeze Homestead Exemption, sometimes called the Senior Freeze. Which of the following best describes what this exemption accomplishes? Your options are: A. Increases the general homestead exemption tenfold for seniors. B. Eliminates property taxes for life on the principal residence. C. Reduces the property tax rate by half each year. D. Freezes the equalized assessed value at the base qualifying year. Take a second. Which answer would you pick? The correct answer is D. Freezes the equalized assessed value at the base qualifying year. D is correct because the senior freeze under 35 ILCS 215-172 freezes the equalized assessed value at the base year in which the senior first qualified. The EAV does not rise as long as the senior continues to qualify, even though tax rates and other factors may still affect the actual bill. A is wrong because the general homestead exemption and the senior freeze are separate programs with different mechanisms. The senior freeze does not multiply the general homestead exemption, and the two operate together to give qualified seniors layered protection against rising tax bills. B is wrong because eliminating property taxes for life would amount to a permanent and total tax exemption, which the senior freeze does not provide. The exemption controls the assessed value rather than the entire tax bill, and the senior still pays at the prevailing rate against a frozen value. C is wrong because tax rates are set by individual taxing districts based on their levies, not by individual homestead exemptions. The senior freeze does not reduce any rate. It stabilizes the assessed value the rates are applied against, leaving the rates themselves to operate normally. The Senior Citizens Assessment Freeze Homestead Exemption Agreement, known as the Senior Freeze, protects qualifying older homeowners from rising property tax bills caused by climbing assessed values. Understanding how it works requires knowing exactly which part of the tax calculation it touches. Property taxes are calculated by multiplying the equalized assessed value, the EAV, by the tax rate set by local taxing districts. The senior freeze locks the EAV at the base year level, so even as market values climb, the value side of the equation stays frozen. The rate side is unaffected and can still rise. To qualify, a homeowner must be 65 or older, must occupy the property as their principal residence, and must have total household income below the threshold set by the Illinois Department of Revenue. The exemption is claimed by annual application filed with the county. The senior freeze is distinct from the other two common exemptions. The general homestead exemption reduces the EAV by a fixed dollar amount for any homeowner. The Senior Citizens Homestead Exemption gives an additional reduction for owners 65 and older regardless of income. The senior freeze layers on top of both for income qualifying seniors, freezing the remaining EAV in place. The senior freeze does not eliminate taxes and does not freeze the tax bill itself. It freezes the value side of the calculation, shielding fixed income seniors from escalating assessed values while the rate side continues to operate normally. Question 27. The Cook County Just Housing Amendment, effective in 2019, regulates how landlords may screen tenant applicants using criminal background information. Which of the following best describes a key requirement of the Just Housing Amendment? Your options are: A. Permits blanket bans on applicants with any conviction. B. Requires individualized assessment with 3-year look-back limit. C. Prohibits all criminal background screening of any kind. D. Applies only to government-subsidized housing units. Before I reveal it, which one do you think is right? The correct answer is B. Requires individualized assessment with 3-year look-back limit. B is correct because the Cook County Just Housing Amendment requires landlords to conduct pre-qualification first, then permits an individualized assessment of criminal history with a 3-year look-back limit. Older convictions, juvenile records, arrests not resulting in conviction, and sealed records cannot be considered. A is wrong because blanket bans on applicants with any conviction are precisely what the Just Housing Amendment prohibits. The ordinance was enacted to require individualized assessment rather than categorical exclusion based on the mere existence of any criminal history, regardless of the specifics. C is wrong because the Just Housing Amendment does not prohibit all criminal background screening. It allows screening within strict procedural and substantive limits, including the 3-year look-back, individualized assessment requirement, and protections against considering certain categories of records. D is wrong because the Just Housing Amendment applies broadly to rental housing in Cook County, including incorporated areas with their own ordinances and unincorporated areas covered by Cook County. It is not limited to government-subsidized housing units alone. The Cook County Just Housing Amendment regulates how landlords screen rental applicants using criminal background information. It's part of the Cook County Human Rights Ordinance and took effect in 2019, making it one of the strongest fair housing style protections in Illinois. The amendment flips the traditional screening sequence. First, the landlord must evaluate credit, rental references, and income without considering criminal history at all. Only after the applicant pre-qualifies on those factors may the landlord review any criminal background information. Even when criminal history is reviewed, strict limits apply. Convictions older than 3 years are generally off limits, and that clock runs from the end of the sentence. Juvenile records, arrests not leading to conviction, and sealed or expunged records are excluded entirely, regardless of how recent they are. Categorical bans, like rejecting anyone with any conviction, are precisely what the ordinance prohibits. The landlord must weigh the nature and severity of the offense, time elapsed, the applicant's age, evidence of rehabilitation, and the relationship between the offense and tenancy risks. The applicant must also have the opportunity to dispute inaccurate records. The lasting lesson of the Just Housing Amendment is that criminal history can never trigger an automatic denial in Cook County. Pre-qualification comes first. Look-back limits narrow what records matter, and individualized assessment governs the rest. Question 28. A buyer in Schaumburg places earnest money with the listing broker as a deposit on a residential purchase contract. The deal falls through and the parties dispute who is entitled to the funds. Under 225 ILCS 454/2020, after how many days may the broker disburse with proper notice? Your options are: A. 180 days from start of dispute, B. 90 days from contract signing, C. 30 days from receipt of dispute, D. 1 year from the date of breach. What's your answer? Commit to one before I continue. The correct answer is A. 180 days from start of dispute. A is correct because under Illinois practice and 225 ILCS 454/2020, The broker may disburse earnest money after 180 days with proper notice to both parties when buyer and seller dispute entitlements. Alternatively, the broker may file an interpleader action in court for judicial resolution. B is wrong because 90 days does not match the Illinois earnest money dispute procedure. The statutory period is significantly longer, reflecting the legislature's policy of giving parties time to negotiate, mediate, or litigate before brokers can step in unilaterally on the disbursement. C is wrong because 30 days is far shorter than the Illinois rule for disputed earnest money. The legislature provided a longer window to encourage the parties to resolve disputes themselves before the broker is permitted to take action under the statutory procedure. D is wrong because 1 year is too long. The legislature struck a balance that gives parties meaningful time to work things out without trapping their earnest money indefinitely. And the actual window expires well before the year mark when proper notice has been given. When a real estate deal falls apart and both buyer and seller claim the earnest money, the broker is stuck holding funds that two parties are fighting over. Illinois law provides a specific statutory framework to resolve this deadlock. The deposit sits in a designated escrow account held by the broker or an attorney. At closing, it is applied to the purchase price. But when the transaction collapses, the broker cannot simply choose a side. Doing so would expose the broker to liability to the other claimant. The statute gives brokers three possible paths: hold the money and wait, disburse after 180 days with proper written notice to both parties, or file an interpleader action asking a court to determine who is entitled to the funds. To use the statutory disbursement path, the broker must wait 180 days from when the dispute begins. Then send written notice to both parties identifying the proposed disposition. If the parties do not resolve it, the broker may disburse as stated in the notice and is generally insulated from liability, but only if every procedural step is followed exactly. The 180-day window is the controlling period on the Illinois exam. It balances meaningful negotiation time for the parties against the risk of funds being trapped in the broker's account indefinitely. Know this number: 30, 90, and 1 year are all common distractors. Question 29. Illinois broker licenses are renewed on a defined cycle, with renewal occurring on a fixed date in specific calendar years. Which of the following best identifies the broker license renewal cycle? Your options are A. Annual renewal every December 31. B. 3-year renewal on licensee's anniversary date. C. Biennial renewal April 30 of even-numbered years. D. Renewal only upon IDFPR notice to renew. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Biennial renewal April 30 of even-numbered years. C is correct because Illinois broker licenses renew biennially with expiration on April 30 of every even-numbered year. Managing broker licenses renew on April 30 of every odd-numbered year. Late renewal triggers penalty fees, and renewal more than 2 years late may require reinstatement procedures. A is wrong because annual renewal every December 31 does not match the Illinois cycle. The state uses a 2-year cycle with April 30th expiration, not the calendar year-end annual renewal pattern that some other professional licenses follow under different state regulatory schemes. B is wrong because anniversary-based renewal would tie each licensee to their original issue date and produce rolling expirations year-round. Illinois standardizes on April 30th instead, which lets the agency process renewals in waves rather than by individual anniversary throughout the calendar. D is wrong because IDFPR notice does not control the renewal cycle. The renewal date is set by statute and rule, with licensees responsible for tracking and meeting the renewal deadline independently of any agency reminder, although IDFPR does send renewal notices as a courtesy. Illinois sets its real estate license renewal on a biennial schedule. Every 2 years, with a fixed expiration date of April 30th. Understanding the structure is key to staying compliant and avoiding penalties. Broker licenses expire on April 30th of every even-numbered year, while managing broker licenses expire on April 30th of every odd-numbered year. This deliberate split lets the Illinois Department of Financial and Professional Regulation process renewals in alternating waves rather than all at once. To renew, a licensee must submit the application, pay the fee, and complete continuing education hours, all before the expiration date. Illinois requires CE in core topics including license law, fair housing, and ethics. Missing the CE deadline triggers a penalty even if the application and fee are submitted on time. The fixed April 30th date is set by rule, not by an individual licensee's anniversary. This lets the agency process renewals in waves and gives all brokers a shared renewal cadence, making the system far more manageable than rolling, anniversary-based expirations. Consequences escalate the longer renewal is delayed. A short delay means a late fee but continuous licensure. Further delay can push the license into lapse status. Beyond 2 years, the licensee may face full reinstatement, including additional fees and a competency demonstration. The licensee is always responsible for meeting the deadline. Reliance on an agency notice is not a legal defense. Question 30. A buyer asks a licensee in Schaumburg whether any registered sex offenders live in the immediate neighborhood. The licensee has not investigated this question. Which of the following best describes the licensee's proper response under Illinois law? Your options are A. Research and disclose all registered offenders in the area. B. Affirmatively state no sex offenders live nearby. C. Refuse to discuss any neighborhood topic. D. Refer the buyer to the Illinois State Police Public Registry. Which would you go with? Lock it in before the reveal. The correct answer is D. Refer the buyer to the Illinois State Police Public Registry. D is correct because under 730 ILCS 152-159, a licensee has no duty to research or disclose information about registered sex offenders. The proper response is to refer the buyer to the Illinois State Police Sex Offender Database, which is publicly available, and never to affirmatively misrepresent the information. A is wrong because researching and disclosing registered offenders is not the licensee's duty under Illinois law. The statute specifically relieves licensees of any investigative obligation, leaving the responsibility with the buyer who can access the public registry directly through the state police website. B is wrong because affirmatively stating no offenders live nearby would be making a representation the licensee has not verified and may be false. The statute relieves the licensee from investigating, but does not authorize the licensee to invent answers, particularly when the buyer can check the registry herself. C is wrong because refusing to discuss any neighborhood topic would be unhelpful and unnecessary. The licensee may discuss neighborhood topics generally, simply declining to research sex offender information and referring the buyer to the public registry that addresses that specific question. When a buyer or tenant asks a real estate licensee about registered sex offenders in the neighborhood, a specific Illinois statute takes over. It carves out registry information from the licensee's general disclosure duty entirely. The statute is clear on 4 points. The licensee has no investigative duty, must refer the buyer to the Illinois State Police Sex Offender Database, may walk the buyer through accessing it, and must never unverifiably claim no offenders live nearby. rather than researching on the buyer's behalf. The licensee simply redirects that inquiry to the authoritative public source, the Illinois State Police database, where the buyer can access real-time, verified registry information directly. The legislature recognized three realities. Registry data changes constantly. Licensees face liability whether they research and miss an update or wrongly claim the area is clear, and the registry itself is the only reliable real-time source. When an exam question describes a buyer asking about sex offenders nearby, the correct answer is always to refer her to the Illinois State Police Registry, not to research it yourself, not to affirm the neighborhood is clear, and not to refuse to engage. Question 31. Two licensees at the same brokerage firm represent opposite sides of a sale of a Lincoln Park residence, with one designated as the buyer's agent and the other as the seller's agent. Each owes full fiduciary duties to the designated client. Which of the following best describes this arrangement? Your options are A. Dual agency requiring informed written consent. B. Designated agency without dual agency consent at licensee level. C. Sub-agency through the listing firm. D. Transaction brokerage with no fiduciary duties. Don't overthink it. Which one feels right? The correct answer is B. Designated agency without dual agency consent at licensee level. B is correct because designated agency under 225 ILCS 454-1550 uses different licensees within the same firm to represent opposite sides of the transaction. Each designated agent owes full fiduciary duties to the designated client, and no dual agency consent is required at the licensee level under this default Illinois structure. A is wrong because dual agency arises when the same licensee represents both parties, requiring informed written consent. Designated agency uses different licensees, so the dual agency consent is not needed at the licensee level, even though both designated agents operate within the same firm. C is wrong because sub-agency would involve a separate broker acting on behalf of the listing firm. The arrangement here involves two licensees within the same firm, not separate firms in a cooperating relationship through sub-agency, so the sub-agency model does not match these facts. D is wrong because transaction brokerage is a non-representation model that some other states use. Illinois designated agency provides full representation with fiduciary duties to designated clients, which is the opposite of the transaction broker structure, where no fiduciary duties are owed. When two clients in the same real estate transaction are represented by different licensees at the same brokerage firm, Illinois applies a model called designated agency. This is the default rule. It does not require dual agency consent, and it operates automatically unless the firm opts out by written policy. The sponsoring broker designates a separate licensee for each party. Each designated agent owes full fiduciary duties, loyalty, confidentiality, and zealous advocacy exclusively to their own client, not to both parties. The structural separation is what distinguishes designated agency from dual agency. Under dual agency, one licensee, or the firm without designation, represents both buyer and seller, creating an unavoidable conflict of loyalty. Designated agency solves this by assigning each client their own licensee, so competing duties never fall on the same person. The model requires real structural safeguards. Confidential information learned by one designated agent cannot flow to the other. The two licensees may share office space, but they must keep client strategy, pricing intelligence, and negotiating preferences completely separate. Remember, in Illinois, designated agency is the default for same firm transactions. The two licensees represent opposing parties with full fiduciary duties, and no dual agency consent is required at the licensee level. The older dual agency framework simply does not apply when designation is in effect. Question 32. A lender orders a broker price opinion to support an internal loss mitigation review on a delinquent loan secured by a Chicago condominium. The lender plans to use the BPO for the review. Which of the following best identifies a use that is not permitted for a BPO under federal law? Your options are A. Primary basis for originating the mortgage loan. B. Short sale negotiation with the borrower. C. Insurance valuation for claim adjustment. D. Asset valuation for portfolio monitoring. Got a guess? Lock it in. The correct answer is A. Primary basis for originating the mortgage loan. A is correct because Dodd-Frank Section 14 Senatria prohibits using a BPO as the primary basis for originating a residential mortgage loan. BPOs are permitted for loss mitigation, foreclosure, portfolio monitoring, insurance, and litigation, but origination requires an appraisal by a licensed appraiser. B is wrong because short sale negotiation typically allows BPOs because the lender is deciding whether to accept less than the loan balance, not extending new credit. The valuation supports the loss mitigation analysis, which is one of the explicit areas where BPOs remain permitted. C is wrong because insurance valuation for claim adjustment is generally outside the mortgage origination universe entirely. Insurers use various valuation methods including BPOs to settle claims after losses, and federal lending rules on origination do not constrain insurance work. D is wrong because portfolio monitoring is a permitted BPO use because the lender already holds the loan and is tracking changes in collateral value, not originating new credit. Using a BPO at the post-closing stage falls outside the origination restriction that Dodd-Frank put in place. A broker price opinion is a faster, cheaper alternative to a formal appraisal, but federal law draws a hard line around when it can be used. The Dodd-Frank Act of 2010 is the key statute you need to understand. BPOs skip the credentialing, inspection scope, and reporting standards that licensed appraisers must meet. That flexibility is exactly why Dodd-Frank had to define where they cannot be used. Dodd-Frank prohibits using a BPO as the primary basis for determining value in a residential mortgage loan origination. Origination is the high-stakes consumer decision that demands professional appraisal standards. Outside of origination, BPOs remain permitted for loss mitigation, foreclosure proceedings, portfolio monitoring, insurance claims, and litigation disputes. The common thread is that all permitted uses occur after a loan already exists, not at the moment of origination. The lasting rule is simple. The moment a BPO is used as the primary basis to originate a new residential mortgage, it crosses the Dodd-Frank line. Every other context listed, short sales, foreclosures, loss mitigation, stays on the permitted side. Question 33. Under Illinois law governing the Illinois Land Trust, the beneficiary's interest in the property is classified for legal purposes in a way that differs from the trustee's interest. Which of the following best identifies how the beneficial interest is classified under Illinois law? Your options are A. As real property like other deeds, B. As a leasehold interest in land, C. As personal property by statute, D. As a joint tenancy with the trustee. Which one is it? Pause the video if you need more time. The correct answer is C. As personal property by statute. C is correct because Illinois classifies the beneficial interest in the land trust as personal property by statute. This classification has practical consequences for privacy, probat, and conveyance, and it distinguishes the beneficiary's rights from the trustee's legal title in the real estate itself. Is wrong because the trustee, not the beneficiary, holds the real property interest in an Illinois land trust. Treating the beneficial interest as real property would defeat the privacy and probate advantages the structure provides, so Illinois assigns the personal property label instead. B is wrong because a leasehold creates rights to possess and use the land for a term, with rent owed to a landlord. A land trust beneficiary's rights extend far beyond possession, including the right to direct sale or mortgage, so the leasehold characterization does not fit the arrangement. D is wrong because joint tenancy requires the four unities of possession, interest, time, and title, and contemplates ownership of the same estate. The trustee and beneficiary hold fundamentally different interests in the land trust, so the joint tenancy classification cannot describe their relationships. The Illinois Land Trust is a specialized legal structure that departs from ordinary trust principles in one critical way. The trustee holds both legal and equitable title, while the beneficiary's interest is classified as personal property by statute. Understanding this departure is the key to everything that follows. In a conventional trust, legal title goes to the trustee and equitable title goes to the beneficiary. Illinois law collapses both titles into the trustee, leaving the beneficiary with only a personal property interest in the trust itself, not in the underlying real estate. The personal property classification drives several practical consequences. The beneficial interest bypasses real estate probate and instead passes through the simpler personal property probate process. It can also be transferred by assignment rather than a deed, which means no recording requirement. Parties choose the Illinois Land Trust for three core advantages. Privacy, because only the trustee's name appears in public records. Transfer flexibility, because beneficial interests move by assignment. And probate simplification, because the personal property classification avoids the slower real estate probate system. When an exam question describes an Illinois land trust and asks how the beneficial interest is classified, the answer is always personal property. This deliberate departure from ordinary trust analysis is exactly what gives the land trust its distinctive practical advantages. Question 34. A title insurance policy issued to a property owner in Naperville covers defects existing at the policy date that were not excluded. Which of the following best describes the typical duration of an owner's title insurance policy? Your options are A. Annual coverage requiring renewal. B. Coverage only until the next sale. C. Coverage for 10 years from policy date. D. Coverage continues for the duration of ownership. Take a second. Which answer would you pick? The correct answer is D. Coverage continues for the duration of ownership. D is correct because an owner's title insurance policy provides coverage that continues for the duration of the owner's ownership and may extend to certain successors. The premium is paid once at issuance, and the policy protects against pre-existing title defects discovered later during the owner's tenure. A is wrong because annual coverage requiring renewal would be inconsistent with title insurance's one-time premium structure. The premium reflects the lifetime nature of the coverage, which would be impractical to charge annually given the static nature of pre-policy title defects. B is wrong because coverage only until the next sale would create gaps when ownership transfers. Owners' policies typically continue past sale for warranties given to subsequent owners, although the new buyer would obtain its own owner's policy for the new period of ownership. C is wrong because a 10-year coverage limit does not reflect how title insurance works. The policy continues for the duration of ownership rather than expiring on a fixed schedule, and a time limit would create gaps in coverage that the one-time premium structure does not contemplate. Title insurance is unlike most other insurance products. It protects against defects that already existed in the chain of title at the moment the policy was issued. even if those defects aren't discovered until years later. There are two main policy types. The owner's policy protects the property owner's ownership interest. The lender's policy protects the mortgage lender's lien position. Both are purchased with a single one-time premium at closing. No renewals, no expiration dates. The owner's policy remains in force for as long as the insured owns the property. The lender's policy works differently. It shrinks with the loan balance and terminates entirely once the loan is paid off. The one-time premium model works because title defects are facts frozen in the chain of title. Undisclosed liens, forged deeds, misceed heirs, unrecorded easements. Once the policy date is set, the universe of pre-existing risk is bounded, so no recurring premium is needed. When the exam asks about an owner's title insurance policy, remember, coverage lasts for the full duration of ownership. The premium is paid once at issuance, and the policy responds to covered defects discovered even decades later. Question 35. The state takes 2 acres from a 10-acre tract along Interstate 80 for a highway widening project. The remaining 8 acres lose value because they now sit closer to the highway and have reduced privacy. Which of the following best identifies the additional compensation category the owner may claim? Your options are A. Punitive damages for the taking, B. Severance damages to the remainder, C. Consequential damages for inconvenience, D. Liquidated damages by statute. Before I reveal it, which one do you think is right? The correct answer is B. Severance damages to the remainder. B is correct because severance damages compensate the owner for the diminution in value of the remainder parcel when only a portion is taken in a partial condemnation. The owner receives fair market value for the taken land plus severance damages for the loss to what remains. A is wrong because punitive damages punish wrongful conduct and require some form of misconduct. A government's lawful condemnation, even when unwelcome, is not wrongful behavior subject to punitive damages, so the owner has no claim for amounts intended to penalize the condemning authority. C is wrong because consequential damages compensate for losses outside the direct value of what was taken, such as inconvenience or relocation costs. These are not typically part of the just compensation framework, which focuses on fair market value of the parcel plus diminution of the remainder. D is wrong because liquidated damages are pre-specified amounts set by contract for breach. Condemnation proceedings determine just compensation through evidence at trial or appraisal review, not through a fixed statutory formula that would treat all takings as triggering the same dollar amount. When the government takes only part of your property through eminent domain, the compensation owed isn't limited to the land actually seized. The remainder of the property may also lose value, and that loss is what severance damages are designed to capture. Severance damages sit within eminent domain's just compensation requirement. When a partial take-in leaves a remainder worth less per acre than before, the owner is entitled to compensation for that diminution, not just for the land directly seized. Appraisers use the before and after approach. They estimate the entire property's fair market value before the taking, then the remainder's value after. The difference covers both the direct take and any severance damage to the remainder. Picture a 10-acre tract along a highway. The state takes 2 acres for road widening. The remaining 8 acres now sit closer to traffic, losing privacy and value per acre. The owner is owed compensation for both the strip taken and the diminution in the remainder. Don't confuse severance damages with 3 related concepts. Punitive damages require misconduct. A lawful condemnation has none. Consequential damages cover losses like moving expenses outside market value. Liquidated damages are preset contract figures. Only severance damages address the remainder's diminished market value. Question 36. An Illinois purchase contract states that If the buyer defaults, the seller's exclusive remedy is to retain the buyer's earnest money as liquidated damages. The buyer defaults. The earnest money is a reasonable forecast of the seller's likely damages. Which of the following best describes the seller's position? Your options are: A. Seller is limited to retaining the earnest money. B. Seller may also sue for the property's full value. C. Seller forfeits all remedies by accepting the clause. D. Seller must elect within 30 days of breach. What's your answer? Commit to one before I continue. The correct answer is A. Seller is limited to retaining the earnest money. A is correct because a valid liquidated damages clause limits the seller to retaining the earnest money when the buyer defaults. Illinois courts enforce such clauses when the amount represents a reasonable forecast of damages and actual damages would be difficult to estimate at the time of contracting. B is wrong because an exclusive liquidated damages remedy bars additional claims for actual damages above the stated amount. The point of the clause is finality, and treating it as merely the floor rather than the ceiling would defeat the bargained for limitation the parties accepted at signing. C is wrong because accepting a liquidated damages clause does not forfeit all remedies. It substitutes the agreed amount for the open-ended actual damages claim, which is a deliberate choice by the parties rather than a forfeiture of all rights they otherwise would have under the contract. D is wrong because there is no 30-day election requirement when the clause specifies an exclusive remedy. The clause already determined the seller's recovery at the time of contracting, so no election among alternatives needs to occur after a breach has been confirmed. A liquidated damages clause locks in the financial consequence of a breach at the moment the contract is signed. Instead of an open-ended fight over actual damages, both parties know exactly what happens if things fall apart. Courts apply a two-part reasonableness test. The stipulated amount must be a reasonable forecast of probable damages, and actual damages must have been difficult to estimate at the time of contracting. This prevents the clause from functioning as a punishment rather than a genuine pre-estimate of harm. In a residential purchase contract, the earnest money deposit is commonly designated as the liquidated damages amount. If the buyer defaults, the seller retains the deposit and the contract terminates. Critically, the clause operates as an exclusive remedy. The seller cannot also sue for additional actual damages above that figure. The clause delivers three practical benefits. It eliminates the need to prove actual damages at trial. It caps the breaching buyer's financial exposure at the agreed amount, and it gives both parties the finality they bargained for at signing. Remember, when a clause designates earnest money as the seller's exclusive remedy, it sets a ceiling on recovery, not a floor. The seller gets the deposit and nothing more. That exclusivity is exactly what makes the structure work for both sides. Question 37. Effective January 2023, the Illinois Human Rights Act added source of income to its protected classes under 775 ILCS 51103-05. Which of the following best describes what source of income includes for housing discrimination purposes? Your options are only Section 8 housing choice vouchers. B. Only government assistance programs administered federally. C. Section 8 vouchers, Social Security, child support, and other lawful sources. D. Income from employment regardless of source. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Section 8 vouchers, Social Security, child support, and other lawful sources. C is correct because source of income includes Section 8 housing choice vouchers, Social Security, SSE, SSD, child support, alimony, unemployment, veterans benefits, public assistance, and other lawful sources of income. The protection prevents landlords from refusing to consider applicants based on the source rather than the amount of their income. A is wrong because source of income is broader than Section 8 vouchers, including Social Security, child support, and other lawful sources. Limiting the protection to vouchers would understate the scope of the Illinois law, which captures a wide range of legitimate income sources. B is wrong because federal administration of an assistance program is not the determining factor. The protection covers source of income broadly, including state and local programs as well as private sources such as child support and alimony, not just federally administered programs. D is wrong because employment income is one of several covered sources, not the entire scope. The point of the source of income protection is to extend coverage beyond traditional employment to public assistance and benefit-based income that landlords previously excluded from consideration. Illinois added source of income as a protected class under the Illinois Human Rights Act, effective January 1st, 2023. This makes it unlawful for landlords to refuse to consider an applicant based on where their income comes from. The scope of covered sources is intentionally broad, capturing most forms of non-employment income, including Section 8 vouchers, Social Security, child support, alimony, unemployment insurance, veterans benefits, pension income, and public assistance. When screening applicants, a landlord must count all lawful income sources, including voucher payments, as part of qualifying income. Neutral criteria like credit history or an income-to-rent ratio are still permitted, but the landlord cannot refuse to count voucher income or Social Security income when applying them. A landlord may still use neutral screening standards, such as a 2.5 times rent requirement, and may reject applicants who fall below that threshold. What is unlawful is refusing to count a lawful income source, like a Section 8 voucher or Social Security payment, when calculating whether the applicant qualifies. The policy rationale is that screening by income source historically operated as a proxy for protected class discrimination, since voucher holders disproportionately include racial minorities, single mothers, and persons with disabilities. Enforcement runs through the Illinois Department of Human Rights, with remedies including damages and civil penalties. Question 38. 3 Chicago siblings purchase a North Shore investment property together, taking title under language that satisfies Illinois requirements for joint tenancy with right of survivorship. One sibling then conveys her interest to an unrelated investor. Which of the following best describes the resulting ownership? Your options are A. All 3 remain joint tenants together. B. The grantee becomes joint tenant. C. All ownership reverts to the seller. D. The grantee holds as tenant in common. Which would you go with? Lock it in before the reveal. The correct answer is D. The grantee holds as tenant in common. D is correct because a unilateral conveyance by one joint tenant breaks the unity of title and time as to the new owner. The transferred share becomes a tenancy in common with the remaining co-owners, while the remaining siblings keep joint tenancy with right of survivorship between themselves. A is wrong because the grantee cannot become a joint tenant by accepting a deed from one existing joint tenant, because the unities of time and title were not satisfied at the moment of the transfer. The original arrangement among all 3 cannot survive unchanged. B is wrong because joint tenancy requires that all owners take their interest at the same time, by the same instrument, in equal shares, and with equal possession. A grantee taken later through a separate deed cannot satisfy those 4 unities and step into the original joint tenancy. C is wrong because nothing in this transfer triggers a reversion to the original seller. The siblings owned the property as joint tenants, and one of them conveyed her own share to a third party, leaving the prior seller out of the chain of current ownership entirely. when a joint tenant conveys her interest to a third party. That act severs the joint tenancy as to her share, a legal event that eliminates the right of survivorship for that interest. Understanding why requires knowing the four unities that create and sustain a joint tenancy. A joint tenancy requires four unities: time, title, interest, and possession. All four must be present at creation and must continue across all joint tenants. Breaking even one unity as to one tenant severs that tenant's share. When sibling C conveys to an outside investor, that investor did not take at the same moment or through the same instrument as the original joint tenants. The unities of time and title are broken, so the investor cannot join the joint tenancy. The result is a hybrid structure. The two remaining siblings hold their combined 2/3 as joint tenants with survivorship between themselves. The investor holds her 1/3 as tenant in common, unaffected if either sibling dies. The key exam insight is that severance is not all or nothing. Only the conveying tenant's share converts to tenancy in common. The remaining joint tenants continue among themselves, producing the hybrid outcome the four unities rule demands. Question 39. A purchase contract in Chicago includes as-is language stating the buyer accepts the property in its present condition without warranties from the seller. The seller knows of a serious foundation problem but does not disclose it. Which of the following best describes the legal effect of the as-is clause? Your options are: A, bars all claims, including those based on fraud. B, does not waive statutory disclosure obligations. C, eliminates buyer's right to home inspection. D, permits seller to conceal any property condition. Don't overthink it. Which one feels right? The correct answer is B, does not waive statutory disclosure obligations. B is correct because an as-is clause does not waive the seller's statutory disclosure obligations under the Illinois Residential Real Property Disclosure Act or the licensee's independent duty to disclose. Sellers and licensees with knowledge of material defects must still disclose, regardless of as-is contract language. A is wrong because an as-is clause does not bar claims based on fraud or violation of statutory disclosure duties. Illinois courts read such clauses against the seller when the seller knowingly conceals material defects, since fraud falls outside what private contract terms can immunize. C is wrong because the as-is clause does not eliminate the buyer's right to inspection. The buyer retains the right to inspect the property through any inspection contingency in the contract and through ordinary due diligence, with as-is language addressing warranties rather than inspection rights. D is wrong because concealing known material defects through silence is fraud, and no boilerplate language can license fraud. Illinois treats deliberate non-disclosure as actionable misrepresentation, regardless of contract phrasing that disclaims implied warranties or other seller assurances at signing. An as-is clause is a standard provision in real estate contracts stating the buyer accepts the property in its current condition. But in Illinois, that clause is far less powerful than many people assume. An as-is clause cannot waive three critical duties. First, it does not eliminate the seller's obligations under the Illinois Residential Real Property Disclosure Act. Second, it does not protect a seller who knowingly conceals a material defect from fraud liability. Third, it does not relieve a real estate licensee of their independent duty to disclose known defects. The Illinois Residential Real Property Disclosure Act requires sellers to deliver a form covering known material defects, including structural condition, plumbing, electrical, heating, and environmental concerns, before the buyer signs the contract. Because this duty is set by statute, no contract provision can erase it. The clause does have real legal effect. It limits implied warranties, can shift inspection costs to the buyer, signals the seller will not repair or credit at closing, and carries significant weight in commercial and distressed property transactions. The lasting principle is simple. An as-is clause allocates condition risk, but it cannot immunize affirmative wrongs. When a seller knowingly hides a material defect, the clause provides no shelter. The buyer's fraud claim and statutory rights remain fully intact. Question 40. Illinois is a lien theory state, and Illinois mortgage foreclosure proceeds judicially under the Illinois Mortgage Foreclosure Law. Which of the following best describes the borrower's right to reinstate a defaulted mortgage under Illinois law? Your options are A. Reinstatement within 90 days after service of complaint. B. Reinstatement within 30 days of demand letter. C. Reinstatement within 1 year of foreclosure filing. D. No reinstatement available once foreclosure is filed. Got a guess? Lock it in. The correct answer is A. Reinstatement within 90 days after service of complaint. A is correct because under the Illinois Mortgage Foreclosure Law, the borrower has the right to reinstate a defaulted mortgage by curing all defaults within 90 days after service of the foreclosure complaint. Reinstatement restores the loan to current status without requiring a full payoff of the balance. B is wrong because a 30-day window would be too short to allow most borrowers to cure default and would not match Illinois statutory procedure. The legislature deliberately built in a longer reinstatement window to give borrowers a realistic chance to save the home from foreclosure. C is wrong because a 1-year reinstatement window would extend well past judgment and into the redemption phase, blurring the two separate borrower rights. Illinois keeps reinstatement and redemption as distinct rights with different time periods and different procedural triggers. D is wrong because reinstatement remains available even after foreclosure has been filed, which is precisely the point of the rights secured during the litigation. Treating foreclosure as the end of reinstatement would defeat the borrower protection the legislature built into the foreclosure statute. When a borrower defaults on a mortgage in Illinois, the law provides a structured opportunity to cure that default and restore the loan before foreclosure runs its course. This right is called reinstatement and it's governed by the Illinois Mortgage Foreclosure Law. Reinstatement lets the borrower catch up on arrears and pay the lender's reasonable foreclosure-related costs without paying off the entire loan balance. The window is 90 days from service of the complaint, and the right can only be exercised once per loan without the lender's consent. The clock starts at service of the complaint, the moment the borrower receives formal notice, not at the date of default or when the case was filed. The legislature chose service to ensure the borrower has actual notice before the 90 days begin running. Reinstatement and redemption are separate borrower protections that operate at different stages. Reinstatement is an early cure right requiring only arrears plus costs. Redemption is a late payoff right, after the sheriff's sale but before court confirmation, I'd say you, requiring the entire loan balance. The key exam distinction is this: reinstatement is the early cure right, 90 days from service of the complaint, requiring only the arrears plus costs. Missing that window doesn't end the case. The redemption right still runs through confirmation of the sheriff's sale. Question 41. A borrower in Schaumburg secures a 30-year fixed-rate mortgage from a local bank to purchase a single-family home. The bank later sells the loan to an investor in the secondary market. Which of the following best identifies the function of the secondary mortgage market? Your options are: A. Originates loans directly to consumers. B. Sets federal interest rate policy. C. Buys and sells existing mortgage loans. D. Approves lenders to do business. Which one is it? Pause the video if you need more time. The correct answer is C. Buys and sells existing mortgage loans. C is correct because the secondary mortgage market buys and sells existing mortgage loans, providing liquidity to lenders who originate in the primary market. Fannie Mae, Freddie Mac, and Ginnie Mae are key institutional players in the secondary market, allowing capital to flow back to originators. A is wrong because originating loans directly to consumers is the function of the primary mortgage market, where borrowers and lenders meet. The secondary market begins after the primary loan is closed, when the originating lender sells the loan to investors or to a government-sponsored enterprise. B is wrong because federal interest rate policy is set by the Federal Reserve and its Federal Open Market Committee. The secondary mortgage market responds to those rates but does not set them, and the institutions buying loans are not policymakers in any sense the Federal Reserve would recognize. D is wrong because approving lenders to do business is the function of state regulators and federal agencies, depending on the lender's charter. The secondary market screens loans for purchase eligibility but does not license or charter the lenders that produce those loans in the first place. The secondary mortgage market is where existing mortgage loans are bought and sold, not originated. It exists one step removed from the primary market where lenders work directly with borrowers. Together, both markets keep capital flowing into residential lending. Here's how the two markets connect. In the primary market, a lender originates a loan directly to a borrower. Then the lender sells that loan into the secondary market, receiving cash to fund the next mortgage. The investor then collects payments and earns interest. The three institutional anchors of the secondary market are Fannie Mae, Freddie Mac, and Ginnie Mae. Fannie Mae and Freddie Mac purchase conventional conforming loans. Ginnie Mae guarantees securities backed by federally insured loans, including FHA and VA loans. The secondary market exists because of a structural mismatch. A 30-year mortgage pays back slowly, but lenders fund themselves with short-term deposits. Selling loans resolves this duration risk and frees up capital. It also creates standardization because lenders originate to meet Fannie Mae and Freddie Mac guidelines. When an exam question asks about the secondary mortgage market, the answer is buying and selling existing loans. It does not originate loans, set interest rate policy, or license lenders. Its core function is providing liquidity and standardization to keep mortgage capital flowing. Question 42. The Illinois Human Rights Act protects against age discrimination in certain contexts. Which of the following best identifies the protected age group under the Illinois Human Rights Act for most housing purposes? Your options are A. All persons regardless of age. B. Persons over the age of 18. C. Persons under 25 years of age. D. Persons 40 years of age and older. Take a second. Which answer would you pick? The correct answer is D. Persons 40 years of age and older. D is correct because the Illinois Human Rights Act protects persons 40 years of age and older in most contexts. This age threshold mirrors the Federal Age Discrimination in Employment Act and provides protection against discrimination by employers and other covered actors in Illinois. A is wrong because protection of all persons regardless of age would be unusually broad. Illinois follows the typical age discrimination model that focuses on protection against bias against older individuals, with the 40-year threshold marking the transition to the protected age group. B is wrong because persons over 18 are not the protected age group under Illinois law. The 18-year mark is the threshold for legal adulthood in most contexts, but is not where age discrimination protection begins under the Human Rights Act for most purposes. C is wrong because persons under 25 are not specifically protected as an age group. The Illinois Human Rights Act addresses discrimination against older individuals rather than younger ones. So the under 25 categorization does not match the statutory protection scheme. Age discrimination law in Illinois and under federal law both hinge on a single threshold, 40 years of age. Understanding where that line comes from and how far it reaches is the key to getting these questions right. When Congress passed the Age Discrimination in Employment Act in 1967, it chose 40 as the floor because data showed hiring discrimination became measurable around that age. Illinois adopted the same threshold in its Human Rights Act. Workers under 40 are not a protected age class under either law. The federal ADEA covers employment only. It does not reach housing, credit, or public accommodations. Illinois extended the same 40 and older protection across all four of these contexts under the Human Rights Act, making the Illinois rule significantly broader than the federal one. Think of the federal ADEA as a single column covering employment, and the Illinois Human Rights Act as that same column plus three more: housing, financial credit, and public accommodations. Both share the 40 and older threshold, but Illinois reaches much further. When an exam question mentions age discrimination and Illinois law, the protected group is persons 40 and older, and the protection extends beyond employment into housing, credit, and public accommodations, areas federal law does not cover. Question 43. A residential landlord in Springfield seeks to terminate a month-to-month tenancy with no cause. Which of the following best identifies the notice period required under the Illinois Eviction Act for terminating a periodic tenancy of month-to-month duration? Your options are A. 5 days notice to pay or quit, B. 30 days written notice to vacate, C. 10 days notice for lease violation, D. 90 days written notice in all cases. Before I reveal it, which one do you think is right? The correct answer is B. 30 days written notice to vacate. B is correct because under 735 ILCS 519-207, a month-to-month tenancy requires 30 days written notice for termination by either party. The notice must be properly served and timed to coincide with the end of a rental period. Different notice periods apply to other termination grounds and tenancy types. A is wrong because 5 days notice to pay or quit applies to non-payment of rent under 735 ILCS 590 It is not the notice period for terminating a month-to-month tenancy without cause, since the no-cause termination uses the periodic tenancy rule rather than the non-payment rule. C is wrong because 10 days notice for lease violation applies under 735 ILCS 59210 to violations of lease terms other than non-payment of rent. A no-cause termination of a periodic tenancy is not a lease violation, but the exercise of the termination right inherent in the periodic structure. D is wrong because 90 days written notice is not the standard for month-to-month termination, although year-to-year periodic tenancies use a 60-day notice. The Illinois Eviction Act distinguishes notice periods by tenancy type, with month-to-month using the 30-day measure. Under the Illinois Eviction Act, the notice period required to end a tenancy depends on both the type of tenancy and the reason for termination. Understanding how these rules fit together is the key to applying them correctly. A periodic tenancy renews from period to period until one party gives notice. The most common form is the month-to-month tenancy, but week-to-week and year-to-year arrangements also exist, each with its own notice requirement under the Eviction Act. The Act sets distinct notice periods for each situation. 30 days written notice covers no-cause termination of a month-to-month tenancy. 60 days applies to year-to-year tenancies. 5 days is the pay or quit notice for non-payment of rent, and 10 days applies to other lease violations. For the 30-day notice to be effective, it must satisfy 3 procedural requirements. It must be in writing, it must be properly served, and the termination date must coincide with the end of a rental period. Improperly served notice does not terminate the tenancy. The 30-day rule exists because periodic tenancies are entered with the mutual understanding that either party may end them on proper notice. The legislature chose 30 days to balance the tenant's need to find housing with the landlord's right to regain possession. Question 44. A municipality adopts a comprehensive plan setting out a long-range vision for land use, transportation, public facilities, and economic development across the entire community. Which of the following best identifies the legal role of the comprehensive plan in Illinois land use control? Your options are advisory blueprint guiding zoning decisions. B. Binding ordinance enforceable against owners. C. Federal mandate under the Constitution. D. Real estate marketing tool only. What's your answer? Commit to one before I continue. The correct answer is A. Advisory blueprint guiding zoning decisions. A is correct because a comprehensive plan is generally an advisory blueprint guiding zoning ordinances and other regulations. Illinois municipal authority to adopt comprehensive plans is granted by statute, and the plan informs but does not directly bind property owners until carried out through specific regulations. B is wrong because a comprehensive plan is not by itself an enforceable ordinance against property owners. Implementation comes through zoning ordinances, subdivision regulations, and other specific tools that translate the plan's general policies into rules that owners must follow on their lots. C is wrong because comprehensive planning is authorized by state law, not by any federal constitutional mandate. The federal constitution does not require local communities to plan, though once zoning is adopted, federal due process and takings principles do apply to its enforcement. D is wrong because comprehensive plans serve a public planning function, not a marketing role. While developers and brokers may consult plans to anticipate where growth will be supported, the plan's purpose is to guide regulation rather than to promote individual properties or developments. A comprehensive plan is a long-range policy document a municipality adopts to guide land use, transportation, housing, and economic development over a 10 to 20-year horizon. Understanding its legal role is essential for land use law. The plan maps out suitable areas for different land uses, charts the transportation network, and analyzes population and economic trends. It is the policy framework against which individual zoning and subdivision decisions are measured. The plan itself does not bind property owners. An owner does not violate the law simply by using land in a way the plan does not endorse. The plan binds the municipality to maintain consistency between its regulations and the plan's policies. The implementation tools that translate the plan into binding rules include zoning ordinances, subdivision regulations, capital improvement programs, and official maps. Zoning is the most prominent, directly controlling what each parcel may be used for. Courts uphold zoning decisions that align with the comprehensive plan and scrutinize those that contradict it. The plan's power is indirect. It shapes and defends the binding regulations that carry out its vision. Question 45. At closing on a residential property in Schaumburg, the parties prorate real estate taxes between buyer and seller. Illinois bills property taxes in arrears, meaning current year taxes are paid in the following calendar year. Which of the following best describes the proration approach? Your options are A. Taxes proceed with no proration at closing. B. Seller credited for buyer's portion of advance taxes. C. Buyer credited for seller's share of unpaid taxes. D. IDFPR sets the exact proration amount. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Buyer credited for seller's share of unpaid taxes. C is correct because in Illinois, property taxes are paid in arrears. So the seller's share of the current year's taxes through the closing date is unpaid and will be billed to the buyer later. At closing, the seller credits the buyer for the seller's portion, so the buyer can pay the eventual bill. A is wrong because no proration would leave each party responsible for whatever amount they happen to be billed, even though the ownership period does not match the billing period. Proration aligns the tax burden with the actual ownership period during the tax year being measured. B is wrong because seller credit for buyer's advance taxes does not match the Illinois arrears system. The mechanic moves money from seller to buyer at closing, since the seller owes for the time of ownership through the closing date but will not be billed for those taxes personally. D is wrong because IDFPR licenses real estate professionals and does not set tax proration amounts. Proration is calculated from the property tax records and the closing date using customary methods rather than agency-prescribed figures for individual transactions. At every Illinois closing, property taxes must be divided fairly between buyer and seller. The key to understanding how this works is the arrears billing system, and why it means money flows in a specific direction at the closing table. Illinois bills property taxes in arrears, meaning the tax for any given calendar year is not collected until the year after. The first installment is typically due in June and the second in September of the following year. So a buyer who closes mid-year will eventually receive a bill that covers time the seller owned the home. At closing, the seller credits the buyer with an estimated amount equal to the taxes owed for the seller's ownership period. When the actual bill arrives the following year, the buyer pays the full amount, using the closing credit to cover the seller's share. The direction of the credit flows from seller to buyer because of this three-part logic. The seller owned the property for part of the year. The tax bill has not yet been issued at closing, and the buyer will receive and pay the entire bill when it arrives. Whenever an exam question describes an Illinois closing with property tax proration, the answer is always a credit from seller to buyer. The arrears structure is the reason. The seller has not yet paid for the time she owned the property, so she settles up at closing. Question 46. A buyer in Oak Park concludes that a property is worth no more to him than the cost of an equally desirable substitute property nearby. The buyer applies a fundamental valuation principle to limit his offer. Which of the following best identifies this principle? Your options are A. Principle of conformity, B. Principle of progression, C. Principle of anticipation, D. Principle of substitution. Which would you go with? Lock it in before the reveal. The correct answer is D. Principle of substitution. D is correct because the principle of substitution holds that a prudent buyer will pay no more than the cost of acquiring an equally desirable substitute. This principle underlies all three approaches to value, since each compares the subject to alternatives available in the market. A is wrong because conformity holds that value is maximized when properties are reasonably similar in style, size, and use. The principle informs neighborhood character, but does not describe how an individual buyer compares the subject to substitutes when deciding what to offer. B is wrong because progression describes the boost in value a lesser property receives from proximity to more valuable neighbors. It explains why an entry-level home near luxury homes may sell for more, but it does not describe the cap a buyer places on his own offer. C is wrong because anticipation holds that value reflects the present worth of future benefits, such as projected rental income or appreciation. The buyer here is comparing today's substitute properties, not projecting future cash flows. So anticipation is not the controlling principle. The principle of substitution is the foundation of appraisal theory. It states that a prudent buyer will pay no more for a property than the cost of acquiring an equally desirable substitute. setting a rational ceiling on every offer in a competitive market. Think of it this way. If two properties deliver comparable benefits, no rational buyer pays more for one than the other. The substitute's price anchors the buyer's maximum willingness to pay. All three appraisal approaches implement substitution differently. The sales comparison approach uses similar market sales as substitutes. The cost approach treats new construction as the substitute. The income approach treats alternative investments producing similar income as the substitute. In every case, the buyer compares the subject property to an available alternative. The existence of substitutes in the market is what gives the principle its force. The more substitutes available, the more strongly substitution operates. Several related principles work alongside substitution. Conformity, progression, anticipation, and highest and best use each govern different aspects of value. Knowing which principle applies to which scenario, especially on an exam, is what separates a confident answer from a guess. Question 47. An appraiser values a Chicago 2 flat using the income approach by collecting monthly gross rent and dividing the sale prices of comparable properties by their monthly rents. The result allows the appraiser to estimate value from the subject's rent. Which technique is this? Your options are A. Direct capitalization of net income, B. Gross rent multiplier analysis, C. Discounted cash flow projection, D. Cost approach with depreciation deduction. Don't overthink it. Which one feels right? The correct answer is B. Gross rent multiplier analysis. B is correct because the gross rent multiplier divides sale price by monthly gross rent to derive a ratio applied to the subject's rent. It is a common shortcut for small residential income properties when reliable gross rent data is available but detailed expense data is not. A is wrong because direct capitalization divides net operating income by an overall capitalization rate to derive value. It works from net income after operating expenses rather than gross rent. So the calculations and data inputs are fundamentally different from the gross rent multiplier method. So is wrong because discounted cash flow projects net income over multiple years and discounts back to present value, often with a reversion at the end. The technique is appropriate for complex income properties, but unnecessary for a 2 flat valued from simple gross rent comparables. D is wrong because the cost approach builds value from reproduction or replacement cost minus depreciation plus site value. It does not involve rent or sale price ratios at all, so it cannot match the technique the appraiser described in this 2 flat valuation exercise. The gross rent multiplier, or GRM, is a shortcut valuation technique used in the income approach to estimate the value of small residential income properties. It works by translating gross rent directly into a value estimate without requiring detailed expense data. The calculation has 3 steps. Collect recent comparable sale prices, divide each by the property's monthly gross rent to get the GRM. Then apply that reconciled multiplier to the subject property's monthly gross rent to estimate its value. The income approach includes 2 main techniques. The gross rent multiplier uses monthly gross rent and suits smaller residential properties where expense data is unreliable. Direct capitalization uses net operating income and a cap rate and is preferred for larger commercial properties with detailed expense statements. Visually, the key distinction is what each technique requires as its input. The GRM needs only sale price and gross rent, no expense analysis. Direct capitalization requires net operating income, meaning expenses must be known and reliable before the technique can be applied. The GRM's simplicity is also its weakness. It ignores differences in operating expenses, does not explicitly address vacancy or collection losses, and produces reliable results only when comparables closely match the subject in size, age, condition, and tenancy profile. Question 48. Which of the following best explains why a property's street address, however accurate for mail delivery, is not accepted as the legal description in a deed or mortgage to be recorded with an Illinois county recorder? Your options are addresses can change over time. B. Mail carriers do not survey land. C. It violates the Illinois Plat Act. D. Recorders only accept handwritten descriptions. Got a guess? Lock it in. The correct answer is A. Addresses can change over time. A is correct because a street address is an administrative label that municipalities and the post office can renumber or rename without affecting the underlying parcel. A legal description must identify the precise boundaries through a method that remains tied to the land itself. B is wrong because whether mail carriers survey land has no bearing on the legal sufficiency of a description. The deeper problem is that addresses describe a delivery point on a building, not the boundaries of the land beneath and around it. C is wrong because the Illinois Plat Act regulates subdivision of land into smaller tracts and exempts certain divisions, such as transfers of more than 5 acres without new streets. The Act does not address the unrelated question of address sufficiency in deeds. D is wrong because modern county recorders accept typed and electronically prepared documents. The recorder's acceptance practices are not the reason a street address fails as a legal description, since handwritten address-only deeds would fail for the same reason as typed ones. When a deed or mortgage is recorded, it must include a legal description, a precise identification of the land itself, not just a mailing address. Understanding why this matters gets to the heart of how the recording system works. There are 3 accepted methods: meets and bounds, which traces the perimeter by courses and distances; lot and block, which references a recorded plat; and the rectangular survey system, which references sections, townships, and ranges on a coordinate grid. Every method is permanently tied to the land itself. The lot and block method, for example, ties a property's identity to a plat recorded in a county plat book. That reference survives any future street renaming or address renumbering because it points to a physical survey, not a postal label. A street address is an administrative label that can change without affecting the underlying parcel at all. Cities reorganize address grids, streets get renamed, and postal routing gets updated. None of those changes touches the boundary of the land, but each one changes the address, making it an unreliable identifier for a deed that must remain accurate decades into the future. The recording system demands continuity of identity over time. A deed recorded in 1960 must identify the same parcel today. Only a description tied to surveyed boundaries or a recorded plat can guarantee that. A street address simply cannot. Question 49. A buyer in a Lakeview transaction includes an inspection contingency in the purchase contract, giving him 10 business days to obtain a professional inspection and to terminate or negotiate based on the results. Which of the following best describes the buyer's options after a problematic inspection? Your options are: A. Buyer must close regardless of findings. B. Buyer must hire only seller-approved inspectors. C. Buyer may renegotiate, accept, or terminate by deadline. D. Buyer waives all rights by ordering an inspection. Which one is it? Pause the video if you need more time. The correct answer is C. Buyer may renegotiate, accept, or terminate by deadline. C is correct because an inspection contingency gives the buyer the right to renegotiate repairs or price, accept the property as is, or terminate the contract by the contingency deadline. The buyer must act within the contingency window. Otherwise, the right typically expires and the deal moves forward. A is wrong because treating the buyer as obligated to close regardless of findings would render the inspection contingency meaningless. The whole point of the contingency is to give the buyer leverage based on the property's condition, with the deadline marking when that leverage expires. B is wrong because inspection contingencies typically allow the buyer to select an inspector, sometimes requiring that the inspector be licensed or certified. The seller does not approve the buyer's choice of inspector, since doing so would compromise the independence of the inspection process. D is wrong because ordering an inspection exercises the contingency rather than waiving it. The buyer's right to take action based on inspection results is intact until the contingency deadline passes, at which point the deal moves forward subject to remaining contract terms. An inspection contingency is one of the most powerful buyer protections in a residential real estate contract. It gives the buyer the right to have the property professionally inspected and to act on the findings before a firm deadline. The contingency has three structural pieces: the buyer's right to choose a licensed inspector, a defined inspection window, typically 10 business days, and a hard deadline by which the buyer must act on the results. When inspection reveals issues, the buyer has exactly three choices: renegotiate, asking for repairs, a credit, or a price reduction, accept the property as offered, or terminate the contract and recover earnest money. The deadline is the contingency's most critical feature. A buyer who acts within the window keeps all three options intact. A buyer who misses it loses the right to object based on the inspection. Importantly, ordering the inspection exercises the contingency. It does not waive it. The lasting rule is the three-option structure: renegotiate, accept, or terminate, all available until the deadline passes. The contingency exists because buyers cannot fully evaluate a property's condition during showings alone. Question 50. Illinois allows owners of residential real property to designate a beneficiary who will receive title at the owner's death without probate through a properly executed instrument recorded during the owner's lifetime. Which of the following best identifies this Illinois mechanism? Your options are A. Pay-on-death banking instrument, B. Joint tenancy with right of survivorship, C. Standard living trust arrangement, D. Transfer on death instrument under 75 ILCS 27. Take a second. Which answer would you pick? The correct answer is D. Transfer on death instrument under 755 ILCS 27. D is correct because the Illinois transfer on death instrument under 755 ILCS 27 allows owners of residential real property to designate a beneficiary who takes title at the owner's death without probate. The TODI is revocable during the owner's lifetime and must be recorded before the owner's death. A is wrong because pay-on-death banking instruments handle bank account transfers, not real estate. The TODI is the parallel mechanism for residential real estate, providing for non-probate transfer at death of the owner without requiring joint ownership or trust during the owner's lifetime. B is wrong because joint tenancy with right of survivorship is another non-probate transfer mechanism but requires co-ownership during the owner's lifetime. The TODI allows the owner to retain sole ownership during life and designate a beneficiary who takes only at death, which is structurally different. C is wrong because a living trust achieves non-probate transfer through trustee ownership during the settler's lifetime, with the trust continuing after death. The TODI is simpler and does not require a trust structure during life, making it an attractive option for single property estate planning. The transfer on death instrument, or TODI, is Illinois' statutory tool for passing residential real property to a named beneficiary at death, a parasite, completely outside of probate. For a TODI to work, it must be signed, witnessed by two competent witnesses, and acknowledged before a notary. Critically, it must be recorded before the owner's death. A TODI not recorded in time simply fails and the property falls back into the estate. Before the toedown, real estate lacked the simple beneficiary designation that bank accounts and investment accounts already had. Payable on death and transfer on death designations existed elsewhere. The toady created the real estate equivalent. The toady's key advantage over joint tenancy and a living trust is that the owner retains full sole ownership during her lifetime. Joint tenancy creates present co-ownership rights and creditor exposure. A living trust demands ongoing administration. The toady keeps it simple. The transfer happens only at death. The lasting principle is that the toady is the real estate analog to other beneficiary designations. The owner controls the property completely until death, and the recorded instrument does the rest.
You have reached the end of our first question set. For the free complete exam preparation, visit our website, link in the description, where you find thousands more practice questions and comprehensive study guides. Thanks for studying with us today. See you in the next video.